I may be pardoned to mention, my lord. I may be pardoned to mention one matter of restoration, CMPL number 87 of 2023, arising out of writ appeal number 66 2017. This was dismissed for non-prosecution by the then Honorable Chief Justice, my Lord Justice uh, Das, my Lord. And this matter was specially assigned to this bench. Your Lordship, earlier previous occasion, issued notice on the question of delay. And therefore,
My penal mission, my lord. The appellant is in custody near about 8 years. Next week.
Next matter, your lordship. The appellant is in custody more than 7 years. Another is 8 years, your lordship. This one.
Weekly list passover item number 21.
Next item.
Item number 38.
Right. May I please, ma'am? Madam, conviction for life, my lord, for offense 302 of IPC, my lord.
Yes, my lord.
The appellant inside the jail custody since 31st March 2016, and in the meantime, 8 years and 3 months already elapsed, my lord.
Come to the paragraph number 2 of the judgment.
Yes, my lord.
Please place it to the.
The case of the prosecution briefs on short on
Please use the mic properly.
on 30th 3 2016 at about 10:30 p.m. on the fatal data at about 10:30, when the deceased was sitting on the veranda of his house, the accused arrived there being armed with a tangia and assaulted the different parts of his body, my lord. It is also alleged that the accused assaulted the deceased Gorujani by means of an axe, suspecting that he was practicing witchcraft upon his son Somanath Jani. Having been aggrieved, the informant Jagabandhu Bhoi lodged FIR. Jagabandhu Bhoi is the PW3, my lord.
So how many persons died?
One person, Guru Jani.
Eyewitness.
Yes, my lord.
Who is there?
The daughter of a deceased PW12, Maniko Jani.
And who is the doctor who conducted PM?
Dr. my lord, PW8.
All are 5 incised wound you have caused. And cause of death is on account of head injury, spinal cord injury, and open fracture left clavicle, and multiple wounds and its complication thereof. So what PW2 has 12 has stated. Please read it, PW12.
My lord, the occurrence, my lord, chief Para 2, the occurrence of this case took place at about 6 years back on the relevant date of occurrence at about 10 p.m. when my father was singing song on the veranda of his house. The accused Samarajani arrived there and assaulted my father by means of an axe, causing bleeding injury on his head, face, neck, chest, and back, etc. By the time of assault, my father by the accused, I was present near him along with my small child. I also raised hulla such as asare asare and cried. After assaulting my father, the accused fled away to his house. Due to assault of the accused, my father died at the spot. I have married in our village. My husband's house is adjacent to my parents' house. Prior to the occurrence, my parents and my younger sister Bimala were residing in their house. Now my sister
So
Bimala
what
is
is your
married.
submission? How do you overcome this evidence? So also
Well,
the doctor's
the
evidence
case of the
was
defense is that there was no electricity and the dark was there, and I am dispute the identification of the accused minor. And thereafter, one aspect is that that was take in that para in chief exam cross examination of eyewitness. There is electric connection in our village, but there is no electricity in our house by that time of incident. It was dark night.
ବାରଣ୍ଡାରେ ପୁରା ବସିକିନି ଗୀତ ଗାଉଥିଲା।
But it was slightly visible. It is not fact that we are going to sleep about 7 to 8 p.m. The defense
ସେ
will
କଣ ବାହାର ଲୋକ କି accused ଟା ବାହାର ଲୋକ କି?
no mal Odisha madam.
ଓଡିଶା ଲୋକ ବାହାରେ ବାହାର ଯୋଉ ଦାଣ୍ଡ ବସିଛି ବାରଣ୍ଡାରେ ଗୀତ ଗାଉଛି ଆସିଲେ ତାକୁ ମାରିଲେ ଆଉ ସେ କଣ ଆଇଡେଣ୍ଟିଫିକେସନ କଣ ଇଏ କରିବେ ତାକୁ?
କେହି କହିନାହାନ୍ତି ସେ ଟାଙ୍ଗିଆ ଧରିକି ଆସିଥିଲା। ଦିସ୍ ଇଜ ଦ ଆନାଦର ପ୍ଲି ଅଫ ଦ
ଇଏ କଣ କହିଲା କି? ଇଏ କଣ କହିଲା କି?
with an axe କହିଛି but
ଦେଖିଥିବ ଘରେ ଇଏ ବସିଛି ଏକୁଟିଆ ଆଣିଥିବ ମାରିବ ଆଉ କଣ ଆଉ ଦେଖିବ କି କଣ ଡାକି ଡାକି ଯିବ ନା ମୁଁ ଟାଙ୍ଗିଆ ନେଇକି ଯାଉଛି ଆସରେ ମାରିବାକୁ ତମେ ଦେଖିବେ ପାଖରେ ଅଛି ଝିଅଟି ଅଛି ସେ ତା ବାପା ବସି ଗୀତ ଗାଉଛି ଆସି ମାରିଲା ରିପିଟେଡ ବ୍ଲୋଜ ଅନ୍ ଦି ଟପ୍ ସବୁ ଗୁଡାକ ହେଡ୍ ଆଉ ଇଏରେ ଦିଆ ହେଇଛି ଚେଷ୍ଟରେ ନେକରେ and you are in custody during that period you have never been released on bail in the trial court.
no madam.
And what about your criminal antecedent?
No madam.
And during that COVID period also you must have
No madam ବାହାରିନି।
or no? Have you got the custody certificate with you?
ଏଥିରେ ଲେଖା ହେଇଛି ମ୍ୟାଡମ୍ ଜଜମେଣ୍ଟରେ ଲେଖା ହେଇଛି କ୍ଲିୟରଲି ଫ୍ରମ୍ 1/4/2020 ଟୁ ଟିଲ୍ ଡେଟ୍ ମ୍ୟାଡମ୍। ଫ୍ରମ୍ 1/4/2020 ଟୁ ଟିଲ୍ ଡେଟ୍ ମ୍ୟାଡମ୍।
କୋଉଠି?
ଜଜମେଣ୍ଟ ସରି 1/4/2016 ଟୁ ଟିଲ୍ ଡେଟ୍ ଜଜମେଣ୍ଟ ସେକେଣ୍ଡ ପେଜ ମ୍ୟାଡମ୍ ଇନ୍ କଲମ୍ ମ୍ୟାଡମ୍ 1/4/2016 ଟୁ ଟିଲ୍ ଡେଟ୍ detention madam judgment page 2 column number 4 madam
When the judgment was pronounced? Judgment ଟା କେବେ pronounce ହେଲା?
7/9/2022 madam
So from date of arrest ହେଲା
31 ଦିନ ଆରେଷ୍ଟ ହେଲା ଫରୱାର୍ଡ ହେଲା 1/4 ରେ
ହଁ କିନ୍ତୁ ପିରିୟଡ ଅଣ୍ଡରଗନ୍ ରେ ଦେଖଉଛନ୍ତି 1/4
2016 madam 2016 madam
ତାମାନେ କେତେ ହେଲା କି ଆମର 7 years 7 years 7
8 years madam 8 years 3 months madam
criminal antecedent କଣ ଅଛି?
Asking ମୋ ଗାଡି
IN number 78 of 2024. There is an application for bail. The London Council pointed out from the impugned judgment that the petitioner is in judicial custody since 1/4/2016 and submits that he has already undergone more than 8 years of sentence. When a Land Council for the state seeks some time to obtain instruction regarding the criminal antecedent, if any, against the petitioner, put up this matter. Yes.
Item number 40.
Well, item 40 and 41 kindly pass over. I'll ask.
Mr. Ponda କୁଆଡେ ଗଲେ? ନିରଞ୍ଜନ ପଣ୍ଡା 41 ରେ ବି କେହି ନାହାନ୍ତି?
ନା.
Then it will go to Monday.
Yes, ma'am.
Non-obvious like them, non-obvious for the appellant and counsel for the state submits that the matter may be taken up next week. Put of this matter we commencing from 22nd of July 2024. Same order in item number 41. ହଁ ଯୋଉଟା ଚାଲୁଥିଲା ସେ ଆସିଛନ୍ତି ସେମାନେ ନା ନା ଏଇ ଯୋଉ ଜେଲରେ ଅନ୍ କର ଭାଇ ଠିକ ଅଛି ତମ ଦେଖ ସମ୍ବଲପୁର
Yes.
ठीक है
Mr. Gardia,
Yes, Your Lord.
you are audible, no?
Yes.
So, the argument which I earlier resumed will continue.
Yes.
Okay.
May I please, Your Lord? So we are going to page 118.
Yes.
That is Om Prakash alias was Raja for state of Uttaranchal.
Take 9.
118 running page, Lord.
No, para 9.
Para 9, but para 2 is the fact, Lord. Just plus para 2, I am just reading. The appellant was engaged as a servant. That is available at para page 124. 3 lines from the top. The appellant was engaged as a servant at their house about 6 months earlier. According to the prosecution, the day before the incident, it was decided to terminate his services on account of his objectionable behavior.
You are reading which paragraph?
Page 2 loss. Page loss 123.
Okay.
That is was short fact.
Hmm.
And I was reading from para 124, the appellant, 3 lines from the top. 4th line. The appellant was engaged as servant at their house. About 6 months earlier, according to the prosecution, the day before the incident, it was decided to terminate his services on account of his objectionable behavior, and he was informed of the decision. A day later, he indulged in the ghastly attack against the entire family. Now then I am going to paragraph 9, page 128. The circumstances and events unfolded by the evidence of People 1 are incompatible with the innocence of the accused. It is worthy of note that the accused appellant executed his plan to put an end to the lives of the entire family in a calculated manner. First, he directed his attack towards the son of People 1, who was sleeping, so that he will not be able to come to the rescue of others. It was easy for him to kill that sleeping young man. The fact that a stone slab was found on the body would lead to a reasonable inference that the accused would have hit him on the head with that stone so as to prevent any resistance being offered or hue and cry being raised. Then he targeted the ladies who were in the bathrooms. When Brigadier Khanna returned home, he became the next victim. In this scenario, it is difficult to accept the contents of the learned counsel that it would not have been possible for the appellant to single-handedly commit 3 murders one by one using different weapons. The doubt which is sought to be raised by the learned counsels doesn't rest on firm hypothesis. Verse 11, next page, please. As regards the motive for the crime, the High Court, on an analysis of the evidence, found that it could either be a frustrated attempt to commit robbery or it could be for taking revenge against the master and his family. It is in the evidence of Article 1 that the decision to dispense with his services was conveyed to the accused on the previous day because the accused incurred the displeasure of the family on account of his misbehavior, his suspected theft, and his killing or harming the pet birds. That apart, as stated by the accused in his statement under Section 313 CRPC, he was asked to quit the job for having illicit intimacy with the sister of the co-accused, and he was scolded on that account. The accused would have been aggrieved for one or all of these reasons. We are not concerned with the sufficiency or otherwise of the motive which would have prompted the appellant to commit the crime. The correctness of conviction cannot be tested on the touchstone of lack of sufficient motive. If the evidence establishes beyond reasonable doubt that the accused committed the crime, such evidence is available in abundant measures in the instant case, just like the present one. I'm going to page 13. In view of the foregoing discussion, we affirm the conviction of the appellant accused under Section 302 of the Indian Penal Code. The question then is about the sentence. The trial court as well as the High Court categorized it as rarest of the rare cases which warranted the death sentence. After giving our anxious consideration, we are in agreement with the High Court that the sentence of death is the appropriate and proper sentence. In this case, as rightly observed by the High Court, the crime had been cleverly preplanned and committed in a brutal and diabolic manner. 3 out of the 4 inmates of the house in which he was employed were eliminated. There was an attempt to kill the fourth person, Petal 1 also. The accused had inflicted injuries on the young Sarith Khanna in such a cruel manner that his neck was practically severed from his body. Multiple injuries were inflicted on the vital parts of other victims. The cruel tendency of the appellant was very large even in the manner of attack. His antecedents also reveal a cruel and savage behavior on his part. The evidence on record reveals that he killed a pet bird and pierced feathers inside the nose of the hen. He was determined to kill all the members of the Khanna family to take revenge on a flimsy ground. Alternatively, he stooped to the ghastly crime in order to take away the valuables in the house. His conduct and behavior is repulsive to the collective conscience of the society. It is fairly clear that he doesn't value the lives of others in the least. The crime committed by the appellant shocks the conscience of the society at large and of the court, and the facts and circumstances unfolded in the case leave the court with an irresistible feeling that is beyond reformation. Though young he is, as held in Amritlal Someshwar Joshi versus State of Maharashtra, mere young age of the accused is not ground to desist from imposing death penalty if it is otherwise warranted. Moreover, in the present case, none is dependent on the appellant. There are no mitigating circumstances in his favor. The accused is a menace to the society, and it seems to us that the death sentence is the most appropriate punishment in this case. On fact, the case on hand is closest to Amritlal Someshwar case, but the death sentence was upheld. Accordingly, the sentence of death is confirmed, the appeal is dismissed. Thus, the next judgment is Amritlal Someshwar Joshi. Starts from page 131. So, para 18 and 20 I have written, so I have taken it to Lordship to paragraph 2. So that will explain applies on the fact of the case. At page 133.
this decision which you placed, it says about the pre-planning that in the night, all this
Calculated,
thing,
Calculated.
well done.
Calculated.
And he has a bad antecedent.
and the another line towards the end, it is mentioned. Moreover, in the present case, none is the dependent on the appellant.
Yes.
He was the young.
हाँ, तापर के तार family ର ନିର୍ଭର କରିବା पर family କିଛି ନାହିଁ. What is the case in hand?
Yes.
ଏଇ ଯୋଉ ଦି ଜଣଙ୍କର କଣ କେହି ନାହାନ୍ତି ତାଙ୍କ ଉପରେ କିଛି?
Naଙ୍କର wife was she who is staying with her father in her father's house.
Now the surviving son is
Yes,
is not
surviving
here.
son is there in custody
Ah.
along with the father.
And only
and
wife is
Wife.
Wife is left her residence house and she's living. I mean, he's staying with her father.
there.
in a parental home.
After the perhaps the
Yes,
after the
after this
occurrence he had gone.
after this occurrence.
Report
the
was
arrest of
the
the-
house was totally demolished.
Ah,
So she was staying.
wife of that son. That means he is now
No,
staying.
one sister, one daughter of Navin, she's married, and one son died, and one son is in custody.
No, this is wife of this Hemananda.
Yes.
He is staying. She is staying in the parental house.
Hemanand is not married.
Then who is
There's wife of Navin.
Wife
Oh,
of
Navin.
Yes, Hemanand's mother.
Emmanuel Ma.
Oh.
This Ramanand is on that.
And because of the antecedents, court thought that it's impossible to reform this boy, even though that criteria, old age, young age, cannot be a consideration. He used to kill
What is
animal.
what is this prosecution case? Why he killed the entire family members?
was
That is because
Dominated from service.
No,
because
there are
he was a
three-
servant in his house. It was decided for some reason or other. It was decided to terminate his service.
Why?
Just at that is at paragraph 11.
No, is there some this that man was having some affair with
Yes,
somebody?
yes,
That's
affair. Yes,
So there are three reasons. As is
yes.
shown.
Either
One
they
could
have
be for that,
yes,
the other one could be for termination,
yes,
and the third one for robbery.
yes, robbery.
Ah.
Maybe they are.
Could be.
So
But
that
he is
paragraph
having
11.
accident.
Yes.
And he made a plan, entered inside the house in the dead
He
hour.
was there inside. He was the servant.
He
Because-
was the
Yes.
servant.
Oh,
He was
by that time he was not terminated from the service.
No, before the termination, they were decided to terminate it.
Oh,
when they
The-
decided.
Before commission of the crime.
acha.
And one after another he eliminated.
First he targeted the son
Yes,
because otherwise he would have protested
Yes.
on something like
Yes.
a young boy. So he finished it. Then the lady members.
Yes.
Yes, that is how
Yes.
they are saying that he. That is how he executed the
yes,
plan.
yes,
Whom he selected. That is also important.
Yes.
So. But in the case in hand, how do you say that it was a
But I'll come
pre-planned?
to that. Plus, I'll come to that because
Because
it is-
once you place a decision
yes, yes.
and simultaneously, unless you
Yes,
connect the
then-
case
Yeah.
to show that, then if you place all, or let us say 15
Because
decisions,
I do.
huh,
Here in this
once you placing a decision, there must be some kind of link to the factual aspect
Yes.
of this case. You
It
say
is a
that
case. It
I
is a
am
case.
placing because of this.
Yes, boss. It is a case of triple murder. In this case, my humble submission for Lordship is it may be a repetition because earlier also I have argued on the same way.
No, you see, first of all, this accused, the accused, which is he was a habitual offender. So far as this case is concerned, the person who has been sentenced to death is only having a 379 case, and that is not yet been attended finality. That means there is no conviction, right?
Yes.
Then number two, if we come to that, the
Execution of the crime.
no pre-planning. We
Yes.
are going one by one.
Yes.
Pre-planning.
Yes.
So, how do you say that there was any kind of pre-planning that he saw that man going there, finished it? These two ladies
Yes.
may come at that point of time to the tube well, or may follow or may not follow. It is not known to anybody. Might not have, because in the, yes, in the early morning they used to go, but in the evening hours, ordinarily,
from their routine work schedule. From the routine work schedule.
there is nothing that every day three were going.
No,
Have you brought out any evidence? We are saying that you are telling about we are only pre-planning. Just tell us that how you are so sure that these two ladies I will meet in that particular place, and so that.
Because it may so happen otherwise also. That also your lordship can well presume. There, after execution of the,
It may so that after doing this, he was just returning, saw these two family members.
Yes.
Also, yes, they finished it.
Yes.
So, but pre-planning is something different than what.
Pre-planning from the spot, he went towards the village. He went towards the village. It may be in his mind to enter into the house or finish all the family members. But on the way, he might have met these two ladies, where he executed his plan that either partially maybe, because two ladies have been killed at the tube well. So had he not met all the two ladies, he might have gone to the house to finish all the persons who are there.
No,
It might be.
he could have also gone to the house.
Yes.
He has not done. That is exactly Mr. Sarangi also pointing out that if he had intention to finish all the family members, he would not have spared these three eyewitnesses.
No, that there, my humble submission is, we can't peep into the mind of the accused. What is going on there? But thing is that the way he has hit on the cervical spine, that area.
You see, that is a very we are 100%. You can say that from the fact
Cruelty is there. That is
that the manner in which he has killed those person, that is there. But other things which are also necessary to be taken into account.
Well,
you do it, but do it in a pre-planned manner. Is not there is any difference in
no pre-planned? Yes, pre-planned has to be inferred here from this case. Plus, his case has its own facts and circumstances. Two cases cannot be equal. So in this case, the way he has pre-planned, because he knows that when he has waited, or he knows the regular behavior of Giridhari. So when Giridhari came, he just crossed just nearby him, and immediately he struck, on his neck, for which he fell down, only saying, "Oh, there is no other sound," because there is no resistance, nothing else. He has not given a smell to Giridhari. So it is in his mind that I will strike.
After finishing the first assault on the deceased or killing him,
yes,
how he would be so sure that I will meet these two ladies in that near the tube well? Regarding pre-planning to kill all the three deceased.
Yes, plus there his son joined at the second spot of occurrence.
No, other way around, you can say
yes,
that had there been no plan to take away the life of these two,
yes,
even going inside the house,
yes,
he would not have been killed both.
Yes,
that could be one.
Yes, might have killed. Yes, might have killed.
This is how he killed all the three.
Yes.
Because though
yes,
as my senior brother is saying, how could he anticipate that this is the time that he would be confronted? Had it not been so, if his plan was to go inside the house, did he try after this going inside the house to see that anybody else is left?
Well, he could have tried.
Absence of this is showing that he had no plan.
Yes,
that is what.
There was after execution of the at the second spot, killing two persons. There might have he might have changed his mind, or he might not taken further risk to enter into the house, or he has seen that those two children have been taken away inside the house.
He had no scope to see.
Right, sir.
He had no scope.
No scope. And then from there, he has changed his mind. He has gone to his house. So what has happened? In what way he has, executed the plan? Because the plan is there in the mind of the accused, and many judgments your lordship has come across.
He might not be, as you said, he might not have been aware.
Yes.
That these three persons were seeing him, watching the occurrence from their respective houses, because they have not shouted.
Yes.
Rather, immediately they just opened the door half, and then they closed the door because they were anticipating that he may come and attack. So
the man must be in a revolting state.
Right, obviously.
Definitely the person who is watching, anyone who is watching at that particular site, he might have scared, not might have scared, and there the lady along with 2 children, it must have come to her mind that yes, he may come again to the house to kill to kill all of them. And this person has eliminated Giridhari, his wife, and Giridhari is innocent because Giridhari is no way connected except he is the son-in-law of Tiruvati.
Sorry for interpretation. Giridhari is the person who was cultivating mainly the land, and the report indicates Giridhari is the person who was teaching him. Say report.
Teaching is an evidence, then I'll come to that. Absolute kitchen.
Teaching achi jo
This is used to teach.
So why have not taken it in statement under section 313 service? You could have said, you could have taken a plea.
No, that's not that. But
Hearing on the procedural sentence is not evidence.
Teaching specific is not there. Mr. Sarangi,
This is
ଆପଣ ଯୋଉ କହିଲେ ନା this is what use this is three ଜଣ ଭିତରୁ କିଏ ହୁଏତ ଏଇ ସ୍ତ୍ରୀ ଲୋକ ଗୁଡା କହୁଥିବେ କି କଣ
they are neighbors. ଏଇ type ର usually land I mean civil dispute ରେ ସେମାନେ ଏମିତି କୁହାକୁହି ହୁଅନ୍ତି usually. And when he has lost the cases, the civil disputes in the competent court of law, thereafter he has acted in this way. So he doesn't have respect for the system of law even.
When that judgment was pronounced, if you say like
that is not the, but witness have stated.
No, you are making a that after the thing was over, it may be that it might so happened after 3 to 4 years after that judgment was pronounced. Who knows?
Yes,
if you say it immediately, then you must prove that when that judgment was pronounced.
That is PW 1 as stated at page 67 of the paper. People also like notes, I'll take notes. Otherwise, I'm reading it. You'll also get it. Paragraph 2, page 67, PW 1.
PW 1.
Yes, yes. Page 67 of the paper book. Paragraph 2. Much prior to the alleged incident, since the time of my grandfather, there was land dispute among both the families, and for that dispute, the alleged incident happened. Not traverse laws. Not, I mean,
you are advancing an argument that they lost the case. That is why perhaps the teaching was made and immediately he did it. But much prior to.
5 witnesses have stated PW 1, PW 3, PW 5, PW 8, and PW 11. Then your Rosberg will come to page 75. PW 3.
And paragraph 6 of that PW 1, we have marked it. So many civil cases were filed among both the families, but I cannot. They said file in paragraph 6, page 68.
Yes. Well. So many civil cases were filed among both the families, but I can't say the said cases were filed in which courts, by whom, and when. Of course, she must not have learned that. That knowledge, specific knowledge, must have been with Tiruvati. And PW3 has stated at page 75.
So it is not there, let us say, it is not there that immediately the judgment was pronounced and it went against the appellants.
Yes.
So they decided to eliminate, maybe on account of that some teaching was made. It's not like that. It was long since the civil dispute was going on.
The days of father-in-law. Father-in-law Tiruvati.
So there was no such immediate motive, you can say.
Yes.
Of course, in a direct evidence, motive is not required to be established by the prosecution. But whatever you have said that for this reason, he was aggressive and finished it.
Yes.
But
proximate link is not there.
Proximate.
Yes,
that is
proximate link is not there.
The civil dispute is going on. Maybe that whatever report has come, there was some kind of teasing. by the deceased person.
That is regular. But teaching, they were being teased. That is not an evidence loss. And no plea has been taken there by the defense. It is usual phenomenon loss in the countryside area.
Who would have admitted the guilt?
Who admit करते हैं?
Trial କରୁଛୁ
नहीं,
ये admit କରୁଛୁ ମୁଁ ଏଇଥିପାଇଁ ତାକୁ ମାନିଲି teaching କଲା ବୋଲି ଆଉ trial କାହିଁ ହବ?
Yes, anyone else has stated about
yes, plus.
this civil dispute?
Page 75, PW3.
73,
PW3, page 75.
75. अच्छा.
About the dispute, all the family members have said.
Yes.
All landed property, there was long-standing
Dispute between my maternal uncle's family and the family of the accused persons.
Again, the word has been used long-standing.
Yes, boss.
बहुत आगुरु आम भितरे family भितरे जमी जमा नहीं विवाद थिला.
Right. Then PW5 at page 82. Paragraph 4 plus. There was land dispute between both the parties since long. 2-3 civil suits were instituted in which deceased Pirobati had got decree. Nobin, being annoyed, was always telling that by fraudulent means she has obtained the decree, he will kill her. Defense has not demolished this version. Nobin, being annoyed, was always telling that by fraudulent means she has obtained the decree, he will kill her. And both are neighbors. That is clear from paragraph 14 of PW5 at page 84. Actually, Nobin is the immediate neighbor of Pirobati.
ये जो paragraph 8 रे जो confrontation टा करी ची.
Yes, that is PW20.
PW20.
PW20 starts from page 126. Regarding 5 kc confrontation 9. You'll also get it paper page 136.
PW5 रो confrontation टा जोटा.
It is not a fact totality.
Yes, certain ही नहीं. तो which confront करा है?
Right. मोटा ही नहीं.
Are you sure? अनाकौन 5 number साकिरो ना. Profulo Kumar Naik.
Yes, Profulo Kumar Naik. Yes, yes. He has not set up before me that this is Pirobati got decree against the civil case against the accused.
It is a fact
only
that
this
the
is the
witness, namely Profulo Naik, has not stated before me that the deceased Pirobati got the decree against civil case once.
So Nobin, being annoyed, was always telling that by fraudulent means she has obtained the decree, he will kill her. Has remained non-demolished.
Paragraph 8 is not in examination. That is in cross-examination.
It is not a fact. I had not stated before the police that there was land dispute among both the parties.
Cross-examination.
Yes.
It is not in examination. I just stated in examination.
No, paragraph 4, page 82.
PW5, paragraph 4.
4. There was land dispute between both the parties since long.
So rightly it is objected and also confronted from I.
Regarding civil dispute, exactly 2-3 civil suits were instituted in which this is Pirobati had got decree. This Pirobati has got decree, he has not told.
No,
No, yes, that particular line
Naveen being annoyed was always
Yes.
telling. This
Yes.
is important.
Yeah, that is not there.
This has not been stated.
No,
Yes.
Because this is the motive.
Yes. That has remained non-demolished.
No, that has remained on the police.
On demolished.
that is a line ta mane paragraph 7 no last question ta hoji seya. Paragraph 7 no PW5 ro pachara ହେଇଛି ଯେ it's not a fact that you have not stated before the police କୁ हम କହିଛି ବୋଲି ମୁଁ ସେଇଥିପାଇଁ କହିଲି ଯେ କାଳେ ବାହାରି ଥିବ ବୋଲି cross examination
ସେଟା ନାହିଁ 137 ପେଜ ରେ
ହଁ ନାଇଁ ସେଇ ଗୋଟିଏ ଜାଗାରେ cross examination ହେଇଛି ନା ଆଉ କୋଉଠି ଆଉ ନାହିଁ କିନ୍ତୁ ଗୋଟେ ଲାଇନ ବାହାରିଛି paragraph 8 ରେ ସେ ନିଜେ କହିଥିଲା ବୋଲି ମାନୁଛି ଯେ it is a fact that I had stated before the police that since 3 to 4 years
both the parties are silent. It's a fact that I am called to. Yes.
So that is all about the this dispute, civil dispute.
Yes. Civil dispute and motive and consequent motive.
No, para 9, I do not know if relating to land under Khata 105 there was dispute
among both the parties.
It is not a fact that I had deposed on behalf of Piravati in the civil suit initiated between the parties. I do not know if my father had deposed evidence in any civil suit in Savin Khata.
These documents have been proved.
Any document was there? No.
To show that yes, he has deposed in the civil suit in favor of the deceased Piravati. What are those documents filed on behalf of the defense? Any
defense kichhi file karna?
Kichhi nahi.
No. No defense witness has been.
No witness, exhibit be nil. ଖାଲି ତ ପଚାରି ଦେଲେ ହବନି ନା ଯଦି ଏଭିଡେନ୍ସ ଦେଇଛି ବୋଲି ତାର ସାର୍ଟିଫାଇଡ କପି ଅଫ ଦି ଏଭିଡେନ୍ସ ଆଣିକିନି ସେ ପ୍ରିଣ୍ଟ ର କପିଟା ଆଣି ଦେଇଥିଲେ ଯେ ହଁ ଏଇ କେସ୍ ଟା ପିରବତୀ ଫାଇଲ କରିଥିଲା ଏବଂ ପିରବତୀ ତରଫରୁ ଇଏ ସାକ୍ଷୀ ଦେଇଥିଲା ଦିଟା ଡକୁମେଣ୍ଟ ହେଇଥାନ୍ତା ତ ଦେଇନାହାନ୍ତି
ଅଛି
ନାଇଁ to counter his testimony, to counter the testimony of PW5.
ହଁ
If defense has initiated a cross-examination showing that this witness is an interested witness, in that case, you would have come with a certified copy showing that yes, his father or he ever has given deposed.
Okay, you come to the next decision you have relied on. That is that Amrutlal Someshwar Joshi case.
Yes.
Paragraph 18 and 20 you have given. Or any other paragraph you want to place.
Two plus to know the
Fact.
plus.
Place paragraph 2, page 133.
Yes. Parsaram Sadrangani, deceased 1, aged about 77 years, was residing in flat number 602, Link apartment, plot number 357, 13th Road, Khar West, Bombay, along with his son-in-law, Chandru Mirchandani, PWT 2. His daughter Hema, deceased 2, aged 32 years, namely wife of PW2, and his granddaughter Vaishali, deceased 3, aged about 3 years. The flat consists of 2 bedrooms, one with an attached bathroom and a drawing room, a kitchen, and a bathroom and toilet block. This is one retired from service, and one of his daughters, Rukmini, was married to Kishan Ramchandani, for the relevant time was working in Hong Kong. Rukmini, along with her 2 children, had come down to Bombay and stayed with the deceased one for a few days, and thereafter proceeded to Baroda, from where her husband hailed. People 2 was serving as an executive in Messrs. Libas Impex Private Limited, situated at Noriman Point. He used to leave the flat at about 10:30 in the morning and return late in the evening. A month before the date of the incident, his wife, Mrs. 2, had given birth to their second child. The accused was employed 3 months prior to the date of the incident to work as a domestic servant and cook by deceased 1 on a salary of rupees 300 per month. The accused used to reside in the flat and had his belongings and the bedding kept in the flat. Deceased 1 also engaged the services of a maid servant, Parvati Bai, people 3, who used to visit the flat for cleaning the utensils in the morning and the afternoon. Then was on the date of the incident, that is 4/8/1987, people 2 left for his office by about 10 o'clock, and at that time deceased 1, 2, and 3 and the month-old infant child along with the accused were in the flat. People 3 came to wash the utensils by about 3 in the afternoon, and at that time she also saw the accused in the flat, and deceased 1 was resting in one bedroom, and deceased 2 and 3 and the infant child were in the other bedroom resting after having their midday meals. People 3 left the flat after cleaning the utensils. At about 5 p.m., the accused is alleged to have come down from the flat along with 3 or 4 suitcases, and one Ram Bahadur Singh, a watchman of the apartment, saw him, and the accused told the watchman that he was carrying the suitcase to the airport and some articles to the residence of one Ambrish Sangwai, a friend of Rukmini, who had come down from Hong Kong. At about 8 p.m., people to return from the office and rang the doorbell, but didn't receive any response, finding the door to be locked. On the inquiry, the watchman told him that the accused had left in the afternoon with suitcases and some articles tied in a bedsheet. The watchman, however, could not tell him as to where the other family members had gone. Pilotu went to the flat of his neighbor Balani and waited there till late at night, expecting the members of his family to come. And as they didn't come till next day morning, he telephoned to Sabita Sangvi to inquire as to whether deceased 1 and 2 had come to the residence. Having received the negative reply, he also inquired Rukmini at Baroda. Therefore, Pilotu searched for a key maker and got a duplicate key and made in with that. He opened the flat and found the deceased 1 was lying dead on the bed with multiple injuries, and his wife deceased 2 and daughter deceased 3 lying dead in the other bedroom with multiple injuries, and the infant child was lying on the ground. He also found that the whole flat was ransacked and the cupboards were opened and valuable articles were missing, and he noticed that the accused was not seen in the flat or anywhere in the building. This is the altogether fact news. And ultimately the circumstances have been proved, and he has been found guilty and sentenced to death. I'm ready to take your lawsuit, paragraph 18 and 20.
So here is a case where to commit robbery,
Yes,
he had finished the 4 family members, including that infant.
yes, three,
Yeah.
3 plus.
3, yes.
3.
But above that, one aspect is also found to be very important. That is loss of trust.
Yes,
The family members had a trust in the domestic help,
yes,
which
yes.
that is how this has come.
And that has been was described
That's
at
it.
paragraph 20.
Has to be. Has to be.
The last week I'll come to paragraph 18, last line at page 142. The manner of execution of the crime.
Because the head of the family is leaving the entire family with the infant,
Yes,
with a trust on the
yes.
person.
I'm reading the last line. The knife used is a big knife.
Now you come to that.
It's paragraph
paragraph
142.
118 is starts there.
18.
Ah.
8.
Ah.
The last line, I'm reading the last line because prior to that, just was it hasn't explained how
the thing was done.
diabolically the crime has been executed.
Okay.
And now it came to the category of rarest of rare cases.
The accused having become extremely greedy, cleverly pre-planned the commission of the crime at a time when Peter Muku was not in the flat.
He was working as a domestic servant, staying along with the family members in the flat who trusted him. That is plus fourth line from the bottom. The accused, having become extremely greedy, cleverly pre-planned the commission of the crime at a time when Peter 2 was not in the flat and when only the old retired person, a helpless lady, and a child were in the flat. The knife used is a big knife which he must have procured, and he killed the three deceased persons at the time when they were resting after having their meals. He didn't even spare the young girl, Vaishali, this is 3, age over 3 years. Peter 6, who conducted the PM, found 5 inside injuries on the child. He found 32 inside injuries on the deceased one, Sri Parasuram Sandargani, and the doctor opined that many of the injuries individually were necessarily fatal. On deceased 2, Hema Mirchandani, the doctor found 12 inside injuries. And the doctor opined the injuries 2, 3, and 7 were singularly sufficient to cause death in the ordinary course of nature. The medical evidence shows that some of the injuries found on the 3 deceased persons were very serious and would show that assailants practically butchered them. The attack was so brutal, and the same establishes that the accused left no chance for anybody's survival, lest they may figure as a witness, and this heinous crime has been committed in that cruel and diabolical manner only with a view to commit robbery. I come to paragraph 20 plus. Paragraph 20.
One line has been stated. It's a beautiful line. Quotation has been
Yes,
given.
if thou art a master.
If thou art a master, sometimes you have to be blind.
Yes.
If you are a servant, sometimes be deaf. ଆଚ୍ଛା ଆକ୍ୟୁଜ ଯଦି ଦେଖନ୍ତୁ ଆପଣଙ୍କ ଚାକର ଯଦି ଗୋଟେ ଛୋଟ ଛୋଟ କଣ କରିଦେଲା ତାକୁ ଆପଣ ବ୍ଲାଇଣ୍ଡ ହେଇଯାଆନ୍ତୁ। ସିଏ ମନେ କରନ୍ତୁ ଗୋଟେ କଣ ଏଇ ଖାଇ ଦଉଛି ରୋଷେଇ ଘରେ, ଆପଣ ଦେଖିଲେ ଖାଉଛି ଠିକ ଅଛି, ତାକୁ ସେ ସମୟରେ ଅନ୍ଧ ହେଇଯିବା କଥା, ଛୋଟିଆ ଛୋଟିଆ ତା ସାଙ୍ଗରେ ଗୋଟେ ଇଏ କଲେ, ଆଉ ସର୍ଭେଣ୍ଟ ବି ବେଳେ ବେଳେ ମାଲିକ ଗାଳି ଦେଲା ସେ କାଲା ଭଳିଆ ହେଇଯିବ, ଅର୍ଥାତ ଶୁଣିବନି, ନହେଲେ କଣ ନା ଯୋଉ ମାଷ୍ଟର ସର୍ଭେଣ୍ଟ ର ରିଲେସନସିପ ଖରାପ ହେଇଯିବ। ତ କିଛି ଜିନିଷକୁ ମାଷ୍ଟର ଅନ୍ଧ ହେଇଯିବା କଥା, କିଛି ଜିନିଷକୁ ସର୍ଭେଣ୍ଟ କାଲା ଭଳିଆ ହେଇକି ନ ଶୁଣିଲା ଭଳିଆ ବାସ୍ ତାକୁ ଗୁରୁତ୍ୱ ଦବନି।
This gentle adjustment is also fast disappearing.
That is called adjustment. ଗୋଟେ କ୍ୱେଶ୍ଚିନ୍ ପଚରାଗଲା ଯେ ଆଜିର ଦୁନିଆରେ ଭଲ ଲୋକ କାହାକୁ କୁହାଯିବ? ତାର ଆନ୍ସର ହେଲା ଯେ ଯାହାର ସବୁଠୁ ପୁରୁଣା ବନ୍ଧୁ ଥିବ ଆଉ ପୁରୁଣା ଚାକର ଥିବ ସେଇ ଲୋକ ହିଁ ହଉଛନ୍ତି ଭଲ ଲୋକ। ଲୋକ ୟୁଜ୍ ଟୁ ଚେଞ୍ଜ ଫ୍ରେଣ୍ଡସ୍ ଆଣ୍ଡ ସର୍ଭାଣ୍ଟସ୍ ଅଲସୋ। ଭଲ ଲୋକ ମାନେ ସେଇ ସର୍ଭାଣ୍ଟ ସାଙ୍ଗରେ ସେ କେତେ ନୁହେଁ ଯେ ଏମିତି ପୁରା ସ୍ମୁଥ ହେଇଯାଇଥିବ, ବହୁତ ଜିନିଷ ଆସିଥିବ, ସର୍ଭାଣ୍ଟ ବହୁତ ଜିନିଷ ସମୟରେ ବିହେଭିୟର ଖରାପ କରିଥିବ, ଇଏ କରି ଟଲରେଟ୍ କରି ତାକୁ ବୁଝେଇ ବାଜେଇ ଇଗ୍ନୋର କରି। So yes, carry on.
Because from there and from that line again, I'm reading, it is said, if thou art a master, sometimes be blind, if a servant, sometimes be deaf. This gentle adjustment is also fast disappearing. The situation is bad as is evident from the numerous crimes of this nature that are being reported. If this situation continues, life, particularly in urban areas, becomes miserable. It is high time that the state and social organizations should rise to the occasion and do something in the interest of the society. The issues involved in these aspects may be multifaceted, that is social, economical, etc. And he always to resolve have to be worked out with a practical approach. However, in instant case, the strained feelings, if any, between master and servant didn't constitute a motive. Assuming something happened between deceased one, the master and the accused, the servant at the time of occurrence, there is no reason as to why the accused killed him, as well as deceased 2 and even deceased 3, a child aged about 3 years, in such a merciless, brutal, and diabolic manner. It is obvious that only with a view to commit robbery, he committed these ghastly murders. The motive is heinous, and the crime committed is cold-blooded, cruel, and diabolical. There is absolutely no mitigating.
see, ଗୋଟେ ଛୋଟ ଛୁଆ 3 ବର୍ଷର
Yes.
ତୁ ଯଦି ସେଗୁଡାଙ୍କୁ ମାରିଦେଇକିନି ମାନେ ସେ
That is-
ଛୁଆଟାକୁ ନ ମାରିଥାନ୍ତୁ
Yes.
ତାହେଲେ ବି ତୋର ରବରି ଏକ୍ସିକ୍ୟୁଟ
Yes.
କରିବାର କିଛି ଅସୁବିଧା ହେଇନଥାନ୍ତା
Yes.
but in spite of that he killed that child who is aged about 3 years.
Yes.
ଛୁଆଟା କଣ ବାଧା ଦେଇଥାନ୍ତା ରବରି କରିବାକୁ ତେଣୁ ସେଗୁଡାକ ସେଇ ସିଚୁଏସନ କୁ ନେଇକିନି କହୁଛନ୍ତି ଇଟ୍ସ ଏ ଭେରି merciless, brutal, diabolical manner the crime ଟା execute ହେଇଛି.
Sir.
He has not spared even the
A small child
deceased
of
number 3 was aged about
3 years.
with 12 injuries.
With 12. One is 12 injuries, the other one is
The man is 32.
yes, 32 inside wound, one is 12 inside injuries.
So if we compare this particular case which you are placing on to confirm the death sentence and the factual scenario of this case, don't you find that there are a lot of difference between the
Yes,
factual?
That is to the prudent mind loss. It comes, yes, there is a
Except
difference.
that there are 3 deceased in
Yes.
this case
Yeah.
and 3 deceased in the
I do
other
agree.
case.
But
which
here
was-
was ultimately the judgment which are finally your lordship was relied upon while I am calling for the report. To the one by Honorable Justice D.Y. Chandrachud in 3 judgment judgment, and the other one. There you lordship will find the court should not be judge centric because earlier judges have passed this judgment. We should follow it. In a case of death sentence, there very independent approach should be given by the honorable judges who are hearing particular on the question of sentence. And here plus this court should have its independent view. And for that reason, I am showing all the judgment so that your lordship can have an overall view that in what way all those cases have been appreciated by the honorable judges and how this case is to be appreciated. And whether in the present facts and circumstances of the case, whether death sentence is warranted or not.
କାରଣ ଯୋଉ ସେ ଡିସିସନ ଟା ଏବେ ଯୋଉ ଆସିଲା ଯୋଉ
Yes.
ବେସିସ ରେ ଆମେ ରିପୋର୍ଟ କଲ୍ କରୁ ଗୋଟେ କହିଲା ଟୋଟାଲ ଜିନିଷଟାକୁ ତମେ ସ୍କାନ କର
Yes, plus I'll go to that.
ବ୍ୟାକଗ୍ରାଉଣ୍ଡ କୁ ନିଅ ତାର ସବସିକ୍ୱେଣ୍ଟ କଣ୍ଡକ୍ଟ କୁ ନିଅ ଆଫ୍ଟର ହିଜ ଇଏ ଏବଂ ତାର ସୋସାଇଟିରୁ ରିପୋର୍ଟ
Yes.
ଆଣ ଅନ୍ୟାନ୍ୟ ସବୁ ଜିନିଷକୁ ଆଣିକିନି ଦେଖ ଯେ ମାନେ ଲାଇଫ ଆକୁ ଡେଥ ବଦଳରେ ଲାଇଫ ଦେଲେ ଏଇଟା ଗୋଟେ ଟୋଟାଲି ଡିସପ୍ରୋପୋର୍ସନେଟ
Yes,
ଇଞ୍ଜୁରି ହେଲା
Yes.
ଆକୁ ଡେଥ ଛଡା ଆଉ କିଛି ଦିଆ ନ ଯାଇପାରେ
Yes,
यार रिफॉर्म हमारे चांस ही नहीं तो ए टाइप रो सिचुएशन रे सी जो लैंग्वेज यूज
Yes.
करछन दैट इज व्हाई they said that you should collect all kinds of reports.
That is where the option of life imprisonment is foreclosed, they are saying. And death sentence is the only ultimate punishment.
That is, death sentence is the only sentence
Yes.
in a case of would be befitting to this factual scenario. Then you can give. Otherwise, yeah.
Plus next judgment that is Mofil Khan and another. That is page 1 for next page plus. Let's see. For a moment, lost me. It is a civil dispute between brothers. Paragraph 3, you lost me.
3.
3, yes. Here, in this case, the trial court has gave a death sentence, ultimately upheld by the Honorable High Court, then upheld by the Honorable Apex Court. Then one review has been was prepared, and in that case, the death sentence has been commuted to 30 years of non-remitable sentence. Is the case.
That happened in the other case. So you are referring to Justice Chandrachud's
yes,
that also same thing.
The review judgment I have not given, but I will give it to you. The prosecution case in brief is on 6/6/2007 at about 8:30 p.m. One Hanif Khan, referred to as the deceased hereinafter, was offering namaz in the mosque or village Makandu, Jharkhand. The appellant accused and others who are none other than the deceased brothers and nephews approached him and started assaulting him with sharp-edged weapons such as sword, tangi, bhujali, and spade. The deceased succumbed to the injuries inflicted by the accused persons. Leaving the deceased at the spot, the appellant accused and others proceeded towards the house of the deceased, whereupon, hearing the cries of their father, the deceased son, Gufran Khan alias Palla, and Imran Khan had come out on the street. The appellant accused assaulted the two unarmed brothers with the aforesaid weapons, due to which the two brothers collapsed and died in front of their house. Thereafter, the appellant, accused, and others entered the house of the deceased and committed murder of Usman Bibi, wife of deceased, and his four sons, namely Anis Khan, aged about 5 years, Danis Khan, aged about 8 years, Yusuf Khan, aged about 18 years, and Meherban Khan, aged about 12 years. After committing murder of 6 persons, the appellant accused threatened other members of the household, including their mother, Jainub Khatun, of meeting the same fate if they informed the police about the incident, and thereafter left the house, taking away certain documents relating to the lands, passbook, jewelry, etc. Page 155, paragraph 70. The awarding of death penalty has been a matter of serious academic and judicial debate to discern an objective and rational basis for the exercise of the power and to evolve sound jurisprudential principles governing the exercise thereof. In this regard, the constitution-based decision of this court in Jagmohan Singh for the state of UP and Bachchan Singh for the state of Punjab, a three-judge bench decision in Machi Singh, are the leading cases wherein certain principles in the matter of sentencing has been evolved by this court. The broad principles tailored by this court in its judgments provide guidelines to ensure that the discretion vested in the court is not unbridled. Paragraph 18. This court in the aforesaid decisions has evolved the doctrine of the rarest of rare case and put it to test via medium of chatting out the aggravating and mitigating circumstances in a case and then balancing the two in the facts and circumstances of the case. As a norm, the most significant aspect of sentencing policy is independent consideration of each case by the court and extricating a sentence which is the most appropriate and proportional to the culpability of the accused. It may not be opposite for the court to decide the quantum of sentence with reference to one of the other classes under any one of the heads while completely ignoring classes under the other head. That is to say, what is required is not just the balancing of these circumstances by placing them in separate compartments, but their cumulative effect, which the court is required to keep in its mind so as to better administer the criminal justice system and provide an effective and meaningful reasoning by the court as contemplated under section 354(3) CRPC while sentencing. The following broad heads have been ruled out by the successive judgments of this court. That is aggravating circumstances. The offences relating to the commission of crimes like murder, rape, armed dacoity, kidnapping, etc. by the accused with a prior record of conviction for capital felony or offence committed by the person having a substantial history of serious assaults and criminal convictions.
So you placed it in some other case also, I think. You place this aggravating circumstance of that case. Perhaps you are harping on this 9 and then
Yes.
somehow or other 12 ଏଗୁଡାକ ଉପରେ ଆପଣ ହାର୍ପ କରୁଥିଲେ ବୋଧେ ଆମେ ମାର୍କ କରିଥିଲୁ ଏ ଯୋଉ ଏଣ୍ଟାୟାର ଫ୍ୟାମିଲି କୁ ଇଏ କରେ ସେଟା ଆଗ୍ରାଭେଟିଂ ରେ ଯିବ ତାପରେ କୋଲ୍ଡ ବ୍ଲଡେଡ୍ ୱିଦାଉଟ୍ ପ୍ରୋଭୋକେସନ ସେଟା ଯିବ ଏସବୁ କରୁଥିଲେ ଏବଂ ମିଟିଗେଟିଂ circumstance ଯୋଉଟା ନେକ୍ସଟ ପେଜ ରେ ଅଛି
the victim is innocent, helpless.
ହଁ No, innocent helpless relies upon the or हाँ এটা innocent helpless এটা woman helpless woman बाकी mitigating रे page number 157 रे
Yes. The manner and circumstances in and under which the offence was committed. For example, extreme mental or emotional disturbance or extreme provocation in contradistinction to all this situation in normal course. There is no extreme provocation here in this case. Even extreme mental or emotional disturbance. The age of the accused is a relevant consideration but not a determining factor by itself. But here the age is 50 years of Navin at the time of commission of the crime. The chances of the accused of not indulging in commission of the crime, again, and probability of the accused being reformed and rehabilitated. This particular aspect has been given importance in the subsequent judgments. The condition of the accused shows that he was mentally defective and the defect impaired his capacity to appreciate the circumstances of his criminal conduct. This is also not appealed in our case.
No, এটা কোন para psychological problem ଥିଲା ତାର ସେ ଖାଉଥିଲା ଔଷଧ ମାନେ it's not that way but
no insanity was at the time of commission of the crime.
ନାଇଁ ନାଇଁ 5 ବର୍ଷ ହେଲାଣି ନଥିଲା କି ଯୋଉ ଔଷଧ ଖାଉଥିଲା medicine ଗୁଡା
ଖାଉଥିଲା. But it cannot be said that he was mentally defective. And the defect impaired his capacity to appreciate the circumstances of his criminal conduct. Five, the circumstances which in normal course of life would render such a behavior possible and could have the effect of giving rise to mental imbalance in that given situation, like persistent harassment, or in fact leading to such a peak of human behavior that in the facts and circumstances of the case, the accused believed that he was morally justified in committing the offense. Yet this is also not available.
ନା ଯଦି ଜଣେ ସିଏ ତାର ଭାବୁଛି ଜଜମେଣ୍ଟ ହେଇଛି ତ ସିଏ ଭାବୁଛି ଯେ ମତେ ମୁଁ ଅନ୍ୟାୟ ଭାବରେ let us say we are thinking of the mind of the accused ମୋଠୁ ଅନ୍ୟାୟ ଭାବରେ ମୋର ancestral property deprive କରିଦିଆଗଲା ଆଉ ତା ସହିତ ମତେ ଏମିତି ଟିଜିଂ କରୁଛନ୍ତି ଏଇ ଟାଇପର ତା ମୁଣ୍ଡରେ ପଶିଲା we are not in that justified ki not justified we are not
morally justified.
We are just thinking of it. ତେଣୁ ଏକ ତ ମାନସିକ ତାର ପ୍ରୋବ୍ଲେମ ରହିଛି ଯୋଉଥିପାଇଁ ନ୍ୟୁରୋଲୋଜିକାଲ 5 ବର୍ଷ ଧରି ଟ୍ରିଟମେଣ୍ଟ ହଉଛି
No ମାନସିକ ପ୍ରୋବ୍ଲେମ for this because ମାନସିକ ପ୍ରୋବ୍ଲେମ ରହିଛି ଅଦର ଲୋକଙ୍କ ସାଙ୍ଗରେ ଭଲ କଣ୍ଡକ୍ଟ ଶୋ କରୁଛି because
ତାର ମାନେ ସାଇକୋଲୋଜିକାଲ ପ୍ରୋବ୍ଲେମ ଥିଲା
trauma ଅଛି
ସାଇକୋଲୋଜିକାଲ ପ୍ରୋବ୍ଲେମ ଥିଲା ତା ସହିତ କେସ୍ ହାରିଲା ଭାବିଲା ଯେ ମତେ ଏଇ ଯୋଉ
ସବୁ ସରିଗଲା
ମୋର ଏଇ ଯୋଉ ପୈତୃକ ସମ୍ପତ୍ତି ଏମାନଙ୍କୁ ଯୋଗୁ ଯାଇଛି ତା ସହିତ ଏଇ କଣ ଟିଜିଂ ଫିଜିଂ ଯୋଉ ଆସୁଛି ଏଇ ସବୁ ନେଇକିନି ତାକୁ ସେଗୁଡାକ ମଧ୍ୟ ତମେ ମିଟିଗେଟିଂ ସର୍କମଷ୍ଟାନ୍ସ ରେ ନେଇପାରିବ ବୋଲି କହୁଛନ୍ତି
but moral justification ଥିବ ନା ତାର but here moral justification ତାର ନାହିଁ
କଣ ହେଇଛି
मतलब last line he was morally justified in committing the offense whether he can justify morally that yes I should commit the offense because my landed properties have
been ପଶ୍ଚିମ ମୋ ପୈତୃକ ସମ୍ପତ୍ତି ମତେ ଅନ୍ୟାୟ ଭାବରେ ଡିପ୍ରାଇଭ କରିଦେଇଛନ୍ତି ଏବଂ ଏଇ ମାନେ ହିଁ ଡିପ୍ରାଇଭ କରିଛନ୍ତି ତ ସେଇ ଜିନିଷଟା ଯଦି ତା ମୁଣ୍ଡରେ ପଡେ ତା ଲୁକ୍ ଦେଖନ୍ତୁ ତା ପୋଜିସନରେ ନିଜକୁ ରଖନ୍ତୁ ତ ସିଏ ଭାବୁଛି ଏମାନଙ୍କୁ ଇଏ କଲେ ମୋରାଲି we are not saying that whatever he is thinking it is correct but ଏଇଟା other angle ରେ ନିଆ ହେଇଛି ଯେ ତାର ଦୃଷ୍ଟିରୁ ଦେଖିବାକୁ ପଡିବ whether he is thinking it like that or not ତେଣୁ ଭଲ ଜିନିଷ ହଉଛି କଣ cool calculated ଏ ଗୋଟେ ଜିନିଷ ଗୋଟେ ଏଇ ଟାଇପ ର ସିଚୁଏସନ ଆସିଲେ ଜଣେ କାହିଁକି ମାନସିକ ଇଏ ଭିତରେ ଇମ୍ବାଲାନ୍ସ ହେଇଯାଉଛି ସେଇ ଇଏରେ ସେ କରିଦେଇଛି କ୍ରାଇମ ତ ତା ଭିତରେ ଡିଫରେନ୍ସ ରହୁଛି ଯୋଉ କେସ୍ ଗୁଡା ଆପଣ ଇଏ କଲେ ଗୋଟେ ରାତି ଅଧରେ ଯାଉଛି ରବରି କରୁଛି ସମସ୍ତଙ୍କୁ ଫିନିଶ କରିଦଉଛି ଇନକ୍ଲୁଡିଂ ଗୋଟେ ଛୋଟ ଛୁଆ ତ ତା ଭିତରେ ଆଉ ଏଇ ଯୋଉ କେସ୍ ବିଷୟରେ ଡିଫରେନ୍ସ ସେଇଗୁଡାକ ସେ କହୁଛନ୍ତି ମିଟିଗେଟିଂ ସର୍କମଷ୍ଟାନ୍ସରେ ଏଗୁଡାକ ମଧ୍ୟ ନେଇପାରିବ ତାମାନେ ୟେସ୍
where the court upon proper appreciation of evidence is of the view that the crime was not committed in a preordinate manner and that death resulted in the course of commission of another crime and that there was possibility of it being construed as consequence of the commission of the primary crime.
ये जो 7 नंबर केस टा ये जो एग्जांपल टा देइचंदी आमे से जो आउ गोटे केस नुहे गोटे तादरे ये को तादरे अच्छी सेटा भी आसची बोध आइटम थोड़ा से बेंच रे ये रीता सिंगल आई विटनेस तार तीनटा स्टेज रे तीनटा डिफरेंस ऑफ ये रो जुत में हम मध्य जुवेनाइल केस रे तबले से साखीटा देला टोटली अलगा प्रकार से में मोस्ट ऑफ चांद तादरे फाइल करसले जे सेटा रिकॉल करा जाऊ हम रिकॉल कर दे तेणु सेठी मध्य कहउचंती सिंगल केस रे गोटे टोटाली जदि ये नथिबो तमे सेठी डेथ सेंटेंस दबाटा मध्य
So like
ओटा जहां सो लाइट ए जोरा 7 नंबर रे कहउचंती मिटिगेटिंग सर्कमस्टेंस all right you proceed
and here there two eye witnesses to
no we are
Yeah.
I'm going to question it
while determining the questions relative to sentencing policy, the court has to follow certain principles, and those principles are the lodestar besides the above consideration, imposition, or otherwise of the death sentence. The principles have been enunciated. The court has to apply the test to determine if it was the rarest of rare case for imposition of death sentence. In the opinion of the court, imposition of any other punishment, that is life imprisonment, would be completely inadequate and would not meet the ends of justice. Life imprisonment is the rule and death sentence is an exception. The option to impose sentence of life imprisonment cannot be cautiously exercised, having regard to the nature and circumstances of the crime and all relevant circumstances. The method, plan, or otherwise, and the manner, extent of brutality and inhumanity, etc., in which the crime was committed, and the circumstances leading to commission of such heinous crimes. Verse 20 is important. We remind ourselves that the doctrine of the rarest of rare doesn't classify morals into categories of heinous or less heinous. The difference between the two is not in the identity of the principles, but lies in the realm of application thereof to individual fact situations. Sentences of severity are imposed to reflect the seriousness of the crime, to promote respect for the law, to provide just punishment for the offense, to afford adequate deterrent to criminal conduct, and to protect the community from further similar conduct. It serves threefold purposes: punitive, deterrent, and protective. So I come to 57 paragraph at page 166.
So almost all the cases have been taken into account.
Yes, miss. Yes, yes. 57 to 64. That is in 160, last 5 lines, if I'll read of paragraph 57, 7 lines, it would be the paramount duty of the court to provide justice to the incidental victims of the crime, the family members of deceased persons. Therefore, appropriate and proportional sentence requires to be imposed. On one hand, such sentencing would demonstrate respect to those most personally affected by the grief and horror of murder. On the other, it would also be in accordance with the goals of the victims' rights and the principles of restorative justice. There was two children became orphan in this case because in their front, PW 2 and 3, PW 3 and 4, their mother, has been killed, Savitri, and their father has been killed in the field. So, both the children have become orphaned. So, in the line of this judgment, the victim's cry also is to be looked into by the Honorable Court. Paragraph 58 also, in a similar way, in Dhananjan Chatterjee versus State of West Bengal, it has been made clear. Yes, this court has observed that measurement of punishment in a given case depends upon the atrocity of the crime, the conduct of the criminal, and the defenseless and unprotected set of the victim. Further, that imposition of the appropriate punishment is the manner in which the courts respond to the society's cry for justice against the criminal, and just demand that courts should impose such punishment which reflects public abhorrence of the crime. The court highlighted the court's duty to view the rights of the victims of the crime and the society while considering imposition of appropriate punishment.
Where is security guard? No?
Yes. In Ratan Singh for State of Punjab, this court lamenting the unfortunate state of victims, right to protection in India, observed that is very important. It is a weakness of our jurisprudence that the victims of the crime and the distress of the dependents of the prisoner don't attract the attention of the law. Victim reparation is still the vanishing point of our criminal law. This is the deficiency in the system which must be rectified by the legislation. 60. In the context of this turbulent social times, we cannot remain oblivious to the substantial suffering of the victims. It stands as a fact that criminal justice reform and civil rights movement in India has historically only paid considerable attention to the rights of the accused and neglected to the address to the same extent to the impact of crime on the victims. It is not only the victims of crime only that require soothing balm, but also incidental victims like the family, the co-sufferers, and to a relatively large extent the society too. The judiciary has a paramount duty to safeguard the rights of the victim as diligently as those of the perpetrators. So not only have the cry of the victims, but incidental victims like the two orphans who have been examined as PW 3 and 4. In Moyes versus State of MP, this court has deprecated the lenient approach in imposition of the appropriate punishment and observed that it would be a mockery of justice to permit the accused to escape the extreme penalty of law when faced with clear evidence and diabolic acts. This court held that to award the lesser punishment would be to render the justice system of this country suspect, due to which the common man would lose faith in courts. This court approved the harshest punishment in such cases, as here adopting the approach that the accused understands and society appreciates the language of deterrence more than the reformative jargon. In Sevak Perumal versus State of Tamil Nadu, this court stated that undue sympathy to impose inadequate sentence would do more harm to the justice system and undermine the public confidence in the efficacy of law. Society could not long endure under such serious threats, and therefore it is the duty of every court to award proper sentence having regard to the nature of the offence and the manner in which it was executed or committed, etc.
This case is a commission of murder of 8 persons.
Yes.
Including 4 minors, innocent.
Yes, please.
And one of them was physically infirm also.
Yes, please.
That is. Okay, you come to paragraph 63.
Yes, please. I have read 62.
63.
In Sebak Perumal versus State of Tamil Nadu, this court stated that undue sympathy to impose inadequate sentence would do more harm to the justice system and undermine the public confidence in the efficacy of law. Society could not long endure under such serious threats, and therefore it is the duty of every court to award proper sentence having regard to the nature of the offence and the manner in which it was executed or committed. Then paragraph 63. In the instant case, the mitigating circumstances under which the appellant seek refuse have failed to convince us. The age of the appellant is not a relevant circumstance in the present case. They were middle-aged at the time of commission of offence, and their faculties were ripe enough to comprehend the implications of their actions, and therefore don't warrant pardon of this court. Secondly, the circumstance that the appellants have a family and old aged parents, etc., doesn't convince us, especially in the light of the fact that the parents themselves have testified against the appellants act upon uprooting their brother's family and their utter disregard for blood relations. Thirdly, the mere fact that some of the accused persons of young age have been awarded a lesser sentence than death sentence cannot be made a ground for commuting the sentence of death to imprisonment life. The manner in which the crime was committed on the helpless members of a family, including children of tender age and child with locomotive disability, and design of the appellant accused to eliminate the whole family justifies the grant of death sentence. Lastly, the manner of the commission of crime, the diabolic murder of the young and innocent children of deceased Hanil Khan for property and choice of the day of commission of the crime by the appellants belittles the arguments with respect to the possibility of reformation of the appellant and their possible rehabilitation. In our considered view, the rarest of rare cases exists when an accused would be a menace, threat, and antithetical to harmony in the society, especially in cases where an accused does not act on provocation, acting on the spur of the moment but meticulously executes a deliberately planned crime, in spite of understanding the probable consequence of his act, the death sentence may be most appropriate punishment. We are mindful that criminal law requires strict adherence to the rule of proportionality in providing punishment according to the culpability of each kind of criminal conduct, keeping in mind the effect of not awarding just punishment on the society. Keeping in view the said principle of proportionality of sentence, or what it termed as just desserts, for the vile act of slaughtering 8 lives, including 4 innocent minors and a physical infant child, whereby an entire family is exterminated, we cannot resist from concluding that the depravity of the appellant offense would attract no lesser sentence than the death penalty. This judgment has been put to review unless I am giving the judgment.
See. Who judgment? You Justice Chandrachud?
No. This judgment, this Mokil Khan.
Acha.
This has been reviewed.
This is
Reviewed and it was life imprisonment.
This judgment, yes. Then death sentence has been commuted to a sentence of period of 30 years. Non-repeal sentence of 30 years.
on the ground.
On the ground that regarding their rehabilitation, no argument was advanced. Property dispute ଥିଲା ବୋଲେ sir.
ये 14 paragraph 14
Paragraph
बोले ना कोड प्रेस
14. One of the mitigating circumstances is the probability of the accused being reformed and rehabilitated. The state is under a duty to procure evidence to establish that there is no possibility of reformation and rehabilitation of the accused. The death sentence ought not to be imposed save in the rarest of the rare cases when the alternative option of a lesser punishment is unquestionably foreclosed. To satisfy that, the sentencing aim of reformation is unachievable, rendering life imprisonment completely futile. The court will have to highlight clear evidence as to why the convict is not fit for any kind of reformatory and rehabilitation scheme. This analysis can only be done with rigor when the court focuses on the circumstances related to the criminal, along with other circumstances. Then in Rajendra Prahalad Rao Vasnik v. State of Maharashtra, this court dealt with review of a judgment of this court confirming death sentence and observed as under. The law laid down by various decisions of this court clearly and unequivocally mandates that the probability, not possibility or improbability or impossibility, that a convict can be reformed and rehabilitated in society must be seriously and earnestly considered by the courts before awarding the death sentence. This is one of the mandates of the special reasons requirement of section 354(3) CRPC, and ought not to be taken lightly since it involves snuffing out the life of a person. To effectuate this mandate, it is the obligation on the prosecution to prove the court through evidence that the probability is that the convict cannot be reformed or rehabilitated. This can be achieved by bringing on record inter alia material about his conduct in jail, his conduct outside jail if he has been on bail for some time, medical evidence about his mental makeup, contact with his family, and so on. Similarly, the convict can produce evidence on these issues as well. Another decision also has been referred in paragraph 15. It would be profitable to refer to a judgment of this court in Muhammad Manan v. State of Bihar, in which it was held that before imposing the extreme penalty of the death sentence, the court should satisfy itself that death sentence is imperative, as otherwise the convict would be a threat to the society, and that there is no possibility of reform or rehabilitation of the convict after giving the convict an effective, meaningful, real opportunity of hearing on the question of sentence by producing material. The hearing of sentence should be effective, and even if the accused remains silent, the court would be obliged and duty bound to elicit relevant factors. It is well settled law that the possibility of reformation and rehabilitation of the convict is an important factor of which has to be kept into account as a mitigating circumstances before sentencing to death. There is a bounden duty cast on the courts to elicit information of all the relevant factors and consider those regarding the possibility of reformation, even if the accused remains silent. A scrutiny of the judgments of the trial court, the High Court, and this court would indicate that the sentence of death is imposed by taking into account the brutality of the crime. There is no reference to the possibility of reformation of the petitioners, nor has the state procured any evidence to prove that there is no such possibility with respect to the petitioners. We have examined the socio-economic background of the petitioners, the absence of any criminal antecedents, affidavits filed by their family and community members with whom they continue to share emotional ties, and the certificate issued by the jail superintendent on their conduct during their long incarceration of 14 years. Considering all the above, it cannot be said that there is no possibility of reformation of petitioners, foreclosing the alternate option of a lesser sentence and making the imposition of the death sentence imperative. Despite the fact that the Honorable Apex Court has upheld the judgment passed by the trial court and the High Court, in review also, the Honorable Supreme Court has taken note of the possibility of reformation of the petitioners. And on that ground, that has been scaled down to non-reputable life imprisonment, have been sentenced to period of 30 years.
तो जो रिपोर्ट आपण आनिकिनी प्रोड्यूस कले आपण तो प्रोड्यूस करछन ना.
Yes, sir, absolutely.
Is there anything from that report to suggest that there is no possibility of rehabilitation?
For that reason, you'll ask me kindly that judgment Manoj versus State of MP, there plus everything has been decided. How the trial court, while awarding death sentence by the trial court, a hearing on the question of sentence is to be given, and there the procedure has been prescribed by the Honorable Apex Court.
No. When we call for the report,
Yes.
our order is very specific.
That yes,
the manner in which death sentence was imposed by the trial court, all these things were not taken into account. That is the reason has been given for which we called for the report relying on the Honorable Supreme Court. Now you have produced the report.
Yes, Lord. The psychological aspects has been examined by the psychologist.
Everything from the his family members, from the village level, the thing has been by the probation officer. His conduct in jail with the co-convicts or whatever the other prisoners, everything has been come up here.
Yes,
Apart from that, he has got a psychological problem.
Yes,
so this decision, in the end, it is mentioned that there is no reference in the possibility of or reformation to the petitioner, nor the state has to. We want to know that very line, that whatever you have produced before us, is there anything to show that this man who has been sentenced to death, for him there is no possibility of reformation or rehabilitation in the society?
Well, that is in this case not available. Plus, why if you will find Manoj versus State of MP, there you lost me sentencing of present accused, lost me kindly find at if you lost not having the judgment and giving.
You decision गुड़ा आपण देइथिले तातिर अछि
ना आपण मत देथिले जजमेंट रे मु ताको बाहर करछि मु दउछि गोटे जजमेंट कॉपी काढी छी that is plus 2023 2 SCC 353
23 SCC.
Yes, 2023 2 volume 2 SCC.
Who paragraph?
Well, so I'm taking lordship to paragraph 253 running that is 46 page 469. how the Honorable Apex Court has been impressed to scale down the death sentence. This court is of opinion that there can be no doubt that the crime committed by the three accused was brutal and grotesque. The three defenseless victims were women of different age groups, 22, 46, and 76 years, who were caught off guard and severely physically assaulted, resulting in their death in the safety and comfort of their own home. To have killed three generations of women from the family of PW1 is without doubt grotesque. The manner of the offense is also vicious and pitiless. Asalesa and Rohini were stabbed repeatedly to their death, while Megha was shot point blank on the face. The postmortem reflects that the stab wounds were extensive, ranging across the bodies of the victim. The extensive bleeding at the crime scene further reflects cruel and inhuman manner of attack against the three women. The crime in itself could no doubt be characterized as extremely brutal, grotesque, diabolical, revolting, or dastardly manner so as to arouse intense and extreme indignation of the community, as defined in Machi. These are the aggravating circumstances. Then next page was paragraph 254. On an application of the Bachchan Singh test, as clarified and explained in numerous decisions elaborated above, however, the mitigating circumstances need to be considered, and that too liberally and expansively. Prior to the hearing and the sentencing before this court, a direction was issued to the state to, on the basis of personal interviews and prison records, file for each of the accused a psychological evaluation report, a probation officer's report, and prison report, including material on their conduct and work done. Furthermore, each of the accused has placed material on record before this court to demonstrate circumstances of the criminal. Here, from the accused side, nothing has been placed before your lordship. Given that in this case there are three accused.
No, we have given him opportunity.
But they have not. Given that in this case there are three accused, this court cannot barely consider their circumstances collectively and instead find that an individual approach is necessary. Manoj is one of the accused. The material states that Manoj's conduct appears to be disciplined, correctional in nature, and overall satisfactory, barring one physical altercation during an earlier confinement period. He has a wife and two young children with whom he has repaired relations and is regularly in touch with him. He makes special effort to be a part of his growing children's lives, demonstrating strong continued family ties. While in prison, owing to his interest in cricket, he has also taken up the responsibility of being the captain of the jail block team.
Yes, proceed.
I'm again reading 256. Yeah. The material states that Manoj's conduct appears to be disciplined, correctional in nature, and overall satisfactory, barring one physical altercation during an earlier confinement period. He has a wife and two young children with whom he has repaired relations and is regularly in touch with. He makes special efforts to be a part of his growing children's lives, demonstrating strong continued family ties. While in prison, owing to his interest in cricket, he has also taken up the responsibility of being the captain of the jail block team. The probation officer concludes that he seems remorseful and keen to reintegrate into society with his family. Then regarding Rahul Milos, the report received from the superintendent of jail indicates that he too was involved in an altercation with another inmate in his previous confinement period, but his overall conduct appears to be normal and correctional in nature. He has been voluntarily working as a health worker based on his request since 5/1/2021, wherein he helps transport sick inmates to the jail hospital. While in prison, he has completed 12th standard education and proceeded to pursue BCom from IGNOU, New Delhi, in his final year. He actively participates in cultural and spiritual programs conducted in the prison. His family consists of his ailing father, mother, and three married sisters. He expressed concern for his old parents and wished to help them financially by rejoining society. The Neha Milos, the lady accused, her prison records reflect that she had on a few occasions got into fights and exchanged abuses with the other female inmates and the lady guard. lady guard officers in jail. After counseling, however, her conduct was improved and was found to be disciplined and corrective in nature. While in prison, she actively participates in cultural programs, has undergone training for embroidery, knitting, and lamination. In 2017, she received a national award for Jardoshi work in Indore district court, and has received numerous other accolades for her participation in activities. In prison, she teaches children of other female inmates. Before detention, she was pursuing her BCom degree, which she completed in prison. Her family consists of her parents and the two married brothers, of which one is paralyzed, who she is regularly in touch with. Then the conclusion was on sentence of the three accused. It is unfortunate to note that both the trial court and the High Court failed to provide an effective sentencing hearing to the accused at the relevant stage, which is a right under Section 235(2) CRPC, recognized by this court in several cases. In fact, it was argued by the accused that the trial court, in contravention of this court's judgments, had proceeded to hear on sentencing almost immediately, depriving the accused of the opportunity to put for their case for a less stringent sentence.
Yes, it
gap ଅଛି. The trial court order on sentencing records in passing the plea of young age and socio-economic factors as mitigating circumstances, but reflects at best a mechanical consideration of the same. Swayed by the brutality of the crime and shock of the collective and judicial conscience, the High Court affirmed imposition of the death penalty solely on the basis of the aggravating circumstances of the crime, with negligible consideration of mitigating circumstances of the criminal. This is a direct contravention of Bachan-Singh. Paragraph 260. The crime that the appellant have been held guilty of is heinous. Its execution was vicious and cruel by any stretch of imagination. The deception practiced by the appellants in entering the flat and when encountering resistance, attacking the three women, was calculated and ruthless. The repeated stabbings of two of the deceased, almost in a frenzy, on one hand, and the defenseless state of the victims on the other, highlights that the accused were willing to go ahead with their plans of robbing after eliminating the women of three generations. No doubt, two of the victims appear to have put up resistance if one looks at the stab wounds inflicted all over their bodies, including their arms and faces, yet they were unarmed and weak. At the same time, the young age of the accused at the time of the incident, 35, 20, and 22 respectively, and lack of criminal antecedents, except in the case of Manoj, who was allegedly involved in a case of petty theft, cannot be lost sight of. Further, the prosecution case is silent on any real motive that may have instigated or moved the three accused who have pre-planned for the commission of murder other than robbery itself. This, coupled with the fact that Rahul was shot in his leg during commission of the crime, indicates that perhaps it is reasonable to assume that they were amateurs in a robbing gone wrong situation who were not intent on taking the lives of these three women. One can surmise that having ventured to rob, perhaps they didn't contemplate the kind of resistance that was put up by the victims, which led them to act the way they did to continue with their plan and ensure that victims didn't survive to tell the tale. Discussion has been left to the court. So in this way, the court has thought that they're all young by the time of occurrence. And also they have reformed themselves substantially in the jail during their custody. And also they have expressed, yes, to reintegrate into society by giving documents to us. So that death has been commuted with life imprisonment for a minimum, non-inevitable life imprisonment for a minimum term of 25 years.
ଏଠି ଯୋଉ ସିଚୁଏସନ ଟା ଆସିଛି
Yes.
ଜଷ୍ଟ ଭିଜୁଆଲାଇଜ କରନ୍ତୁ ଯଦି ସେ ଦିଟା ଲେଡି ଆଉ କିଛି ଅଧିକା ସମୟ ଘରେ ରହିଯାଇଥାନ୍ତେ
Right.
ଲେଟ୍ ଅସ୍ ସେ ଫର ରେଷ୍ଟ ତାଙ୍କୁ PW5 ଦେଖିକିନି ଆସିଲା ତାଙ୍କୁ ରିପୋର୍ଟ କରିବାକୁ ହେଲା
Right.
ସେତିକିବେଳେ ଏମାନେ ଘରୁ ବାହାରି ଯାଇଥିଲେ ଟ୍ୟୁବୱେଲ ପାଖରେ ଥିଲେ ସେ ବାଟରୁ ଫେରୁଥିଲା ଦେଖିଦେଲା ଲେଟ୍ ଅସ୍ ସେ that for some more time they would have stayed in their house. These two crimes might not have
Yes.
been committed.
Yes, you're also correct. Yes. We can't assume that that person must have entered into the house of the deceased persons and must have killed. That is an assumption. That is
अब ये जो सब जिनसर ଗୋଟେ link रो ना pre plan ये अपन जो pre plan कला बेलू अपन को केवल pre plan for all the three murders, not that pre plan for one.
Pre-planned because I am somebody pre-planned because at the very specific part of the body he has hit every time loss and he has focused on that part.
ଆପଣ ଗୋଟେ ଆର୍ଗୁମେଣ୍ଟ କଲେନି ଯେ ଏମାନେ ସବୁବେଳେ ଯାଆନ୍ତି ତେଣୁ ସିଏ ଜାଣୁଥିବ ଯେ
Yes,
ଆସିବେ।
yes. Because so far as Giridhar is concerned,
ଡିସିସ୍ଡ ଫାଷ୍ଟ ପଳେଇଛି ତାର କିଛି ସମୟ ପରେ ଏ ଦିଟା ଲେଡି ବାହାରିକି ଯାଇଛନ୍ତି ନା ଯାଇକିନି ପାଣି ଇଏ କରୁଛନ୍ତି ସୋ
ପାଣି ନେଇକିନା ଯାଇଥାନ୍ତେ
ପାଣି ନେଇକି ଯାଇଥାନ୍ତେ ସୋ ମିଟିଂ ଇଜ ଜଷ୍ଟ ଏ କୋଇନ୍ସିଡେନ୍ସ କା ଆପଣ କହିଦେଇ ପାରିବେ ସେଇଥିପାଇଁ କୁହାହଉଛି ଯଦି ସେମାନେ ଆଉ କିଛି ସମୟ ଅଧିକା ରହିଛନ୍ତି ତା ଭିତରେ ଫାଷ୍ଟ ମର୍ଡର ଦେଖିକିନି PW5 ଆସିକିନି ରିପୋର୍ଟ କରିଥାନ୍ତା କୋଉଠି ତାଙ୍କ ଘରେ କାରଣ ସିଏ ତ ଫେରୁଛି ନା ସେଇଥିପାଇଁ ଆସିଛି ସିଏ ଆସିଲା ବେଳକୁ ଦେଖୁଛି ଏ ଦିଟା ବି ହେଇଯାଇଛି ସୋ that something ମାନେ every situation has ଆପଣ ଯୋଉ pre-planned for all the three murders that is somehow rather
no, that is in my humble that is in his mind, that must be in his mind that I will eliminate all these persons. Yes, because your last is correct.
case ରେ ହେଇନି ଯେ to eliminate all the family members ଏଠି ଆମର ଯୋଉ rightly pointed out by my esteemed brother ଯେ ସିଏ ତାପରେ ହୁଏତ ଯାଇପାରିଥାନ୍ତା ଆପଣ ଗୋଟେ କହୁଛନ୍ତି ନାଇଁ ସିଏ ହୁଏତ ଧରା ପଡିବ ଧରା ତ ପଡିନି ସିଏ ତ ଘରେ ଆଭେଲେବୁଲ ଅଛି ଅନ୍ୟମାନେ ଆହୁରି 3-4ଟା ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ ରହୁଛନ୍ତି ସେଠିକି ବି ଯାଇକି ଆଟାକ୍ କରିପାର ସେ ବି ସେ କଥା କରୁନି ଆଉ ଏଇ ଯୋଉ ମିଟିଂ ଟା ଏ ଦିଟା ଲେଡି ସାଙ୍ଗରେ
instantaneous
ହେଇଥାଇପାରେ ତ ଆପଣ ଯୋଉ ତାକୁ ଷ୍ଟ୍ରେଚ୍ କରୁଛନ୍ତି ନା ସେ he has an intention because he lost the case to eliminate all the family members
ସେ ପାର୍ଟି କରି ଆସୁନି there is no evidence that ସେଠୁ ସେ ମାରିଲା ପରେ କିଛି ପାର୍ଟି କରି ସାଉଣ୍ଡ କରିକି ଆସୁଛି ସେ ମୁଁ ମାରିଦେଲି କିଛି ସେ କହୁନି he is coming just passing over about 600, 700, 800 meters at least he must have taken 5 if speedily
no, he shouted in the village.
Not shouted, nothing. He is coming 5 to 6 minutes after he is finding
after perhaps but my brother is pointing out that after committing the murder perhaps he told that I have already killed
after committing the murder
Kirmiria
after eliminating both the deceased persons there at the fuel the mari sarla pore se declare kurche mu mar deji Giridhari ko
nahi seya pra
by that time he has not declared or se party kari kisi asuni he is coming and straightway giving a blow to Piravati and his even head virtually has been just with a skin so his nervous system has been devastated both of Piravati that of Giridhari and also subsequently Savitri. Logically see the wounds, the nature of the wounds plus stand.
No, that is Mr. Katkia. That is there is no problem in that. That is
fast plus I humbly pray for Lordship.
Two ladies have been killed, armless, ajuta kojanti, defenseless. The manner in which the crime ସେଗୁଡାକୁ ଗୋଟେ ସାଇଡ୍ ରହିଛି ପୁରା କହୁଛି ଆପଣ ଆମେ କାଲି ଯୋଉ ବାଲାନ୍ସ ଟା ଆମେ ଆପଣଙ୍କୁ କହୁଥିଲୁ ସେଗୁଡାକୁ ଗୋଟେ ସାଇଡ୍ ରେ କିନ୍ତୁ ସାଇମଲ୍ଟେନିୟସଲି କହିଲେ ଖାଲି ତାକୁ ଦେଖିକିନି ଆପଣ ଡେଥ୍ ସେଣ୍ଟେନ୍ସ ଟାର ରେୟାରେଷ୍ଟ ଅଫ୍ ରେୟାର କେସ୍ କରି ଡେଥ୍ ସେଣ୍ଟେନ୍ସ ଦେବେନି ତା ସହିତ ଆପଣଙ୍କୁ ଏଇ ଜିନିଷ ଗୁଡାକ ମଧ୍ୟ ଦେଖିବାକୁ ପଡିବ ଯୋଉଟା କି ସେମାନେ କହୁଛନ୍ତି ଟ୍ରାଏଲ କୋର୍ଟ ଦେଖିନି ହାଇକୋର୍ଟ ବି ଦେଖିନି ତ ସେଥିପାଇଁ ଏଇ ଜିନିଷ ଗୁଡାକ କଲ୍ ଫର କରିବ ଏବଂ ଆପଣଙ୍କୁ ଫାଇଣ୍ଡିଂ ଆଣିବାକୁ ପଡିବ ଯେ ଗୋଟେ ଇଏ ଏମିତିଆ ଗୋଟେ ଲୋକ ରିଫର୍ମ ହେଇପାରିବନି ରିହାବିଲିଟେଟ ହେଇପାରିବନି ଆଉ ଆମେ ଗୋଟେ ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ ଦେଲେ ଗୋଟେ ଟୋଟାଲି ଡିସପ୍ରପୋର୍ସନେଟ ହବ ମାନେ ଇଟ୍ ଉଡ୍ ସକ୍ ଦି କନସେନ୍ସ ଅଫ ଦି ସୋସାଇଟି ଯେ ଏଭଳିଆ କେସ୍ ରେ ମାନେ ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ ଦିଆଯାଉ ଏଇଗୁଡାକ ଏଇ ସବୁ ବିଭିନ୍ନ କେତେ ଗୁଡାକ ନେଇକିନି ତାକୁ ଜଜ୍ କରିବାର ଅଛି
and the other principal factor that the victims cry and also the victims families cry also is to be looked into by this also.
That is correct.
Yes, that part is there.
ଏଠି ଆପଣ ଯୋଉ କହୁଛନ୍ତି ଯେ ଛୋଟ ଛୁଆ ଦିଟା ରହିଗଲେ ତାଙ୍କର
they have become orphan their entire life
they have become orphan
put to misery
that is also to be taken across ବହୁତ ଜିନିଷ ଗୁଡାକୁ କନସିଡର କରିବାକୁ ପଡିବ it's not that ଖାଲି ଯେ brutality of the crime in itself is not a thing which is to be
and here was in the crime test what are the aggravating circumstances in the present case. Plus, I have stated for Lordship that is a cold blood murder and it has been debated here. And victims were helpless and undefended. Plus, because Giridhari doesn't have any fault except being the son-in-law of Piravati and being the husband of Savitri.
He was looking after the cultivation. He was looking after Puram. He was staying there.
He was staying there. He was ill at there
after the cultivation.
Yes.
So maybe that he was also looking after that case also on behalf.
That is no evidence. He was looking after the case. The Pirobati was looking after the case. That is there in evidence.
No,
But
Pirobati.
Giridhari only the son-in-law because having the Savitri husband. In that way, he's
ଆପଣ
ଘରକୁ ହେଇକି ଆସିଲା ପରେ ସେ
ଜମିକୁ ଯାଉଥିଲା କ୍ଷେତ କଥା ବୁଝାବୁଝି କରୁଥିଲା ଏସବୁ ତ ଆପଣ ଡିସ୍ପ୍ୟୁଟ କରିପାରିବେନି କାରଣ କ୍ଷେତରେ ହିଁ ଜମି ଏବଂ ଅଛି ମଧ୍ୟ ଯାଉଥିଲେ ମଧ୍ୟ ସବୁବେଳେ ଯାଆନ୍ତି ୟୁଜ ଟୁ ଗୋ ଏଇ ଟାଇପର ତେଣୁ
from the point of view of Girdhari, you can say that there was nothing from propagative.
Yes, yes, that is also. And victims were not even given a chance or in a position to offer any resistance because he struck, the accused struck in such a manner, none out of the three, none has got a chance to defend himself. They even could not smell that he is coming to attack. Only Savitri, because she found that yes, my mother is being attacked, when she wanted to rescue her mother, then she was assaulted severely by the accused.
That is a spontaneity that she has shown. That is spontaneity.
ମାଠକୁ ଆଗେ assault ହେଇଛି obviously ଝିଅର reaction ବି ସେଇଆ ହଉଛି so ଝିଅଟାକୁ ତାପରେ assault ହେଇଛି ତ ଏଇଟା ନୁହେଁ ଯେ ତାକୁ ଆସିକି ସେଠି କୌଣସି କଳି ଝଗଡା ହେଇଛି ଏବଂ ସେତେବେଳେ ପର୍ଯ୍ୟନ୍ତ ଯାହା ଏଭିଡେନ୍ସ ଅଛି ସେତେବେଳେ ପର୍ଯ୍ୟନ୍ତ ମଧ୍ୟ ଡିସକ୍ଲୋଜ ହେଇନି ଯେ he has committed the murder of Giridhar ହେଲା.
And this has spread a horror, even killing spree, because 3 in a row having been killed by the accused in a village, no doubt must have spread a horror killing spree in that particular locality. And the other factor is neck is placed at such a part of the body. It is not easy to strike unless someone focuses that much. And this cervix, I mean, I am giving a lordship.
Whose neck has been cut?
Yes.
Almost.
If someone knows, it is very difficult to strike at the neck. Because if someone knows, immediately he will move the neck to either right side or bend the neck or something else like that.
No, ହାତର ରେଜିଷ୍ଟାନ୍ସ ବି କରିଦିଏ ଅଟୋମେଟିକ ଉଠିବ ଗୋଟେ ତାର ଇମ୍ପଲ୍ସ ହଉଛି ସେଇଆ ଆପଣ କିଏ ଯେ ମୁଣ୍ଡକୁ ଆଇଲା ଆପଣ ପ୍ରୋଟେକ୍ସନ ଦେବେ ଅଟୋମେଟିକ ହାତ ଉଠିଯିବ.
She has struck on cervical area.
They did not get any scope to that. Yes. So in all the 3 cases, there is hacking on the neck.
Yes. Mostly on the neck or on the face.
All on the face.
Yes. So Lords, we can see the area where the one is C2, one is C6.
ସମସ୍ତଙ୍କର କଣ ଏଇ ଏରିଆରେ ମାଡ
No. What is C2 ରେ ମାଡ କଣ?
Pirobati only one finished.
No, but that means he was taking chanceless.
Yes,
PM report ଟା କେତେ
It is for PW6 at page 86. Plus page 87, that is of Savitri. One chopped wood of size 6 cm into 3 cm into 3 cm over right cheek, 1 cm in front of right ear. It must be bony injury, even if the doctor has not stated so. This court can also inform there must be bony injury, 3 cm and 3 cm and 3 cm.
এই জায়গায় মারা হয়েছে
4 cm thickness, 6 cm thickness ହେଲା ମାନେ ତ bony injury ନିଶ୍ଚିତ ଥିବ. One chopped wound of size 4.
Last ଟା ହଉଛି depth.
Yes.
3 cm ଟା depth. Yes.
The one chopped wound of size 4 cm into 3 cm into 3 cm over left cheek. And one chopped wound of size 6 cm and 3 cm and 3 cm over base of right side of neck. Neck of base. There the cause of death was due to multiple chop wound over head and neck by sharp and heavy weapon. Well, then the logic will come to Pirovati. This is one chop wound, paragraph 7. One chop wound of size 6 cm into 4 cm and 4 cm on back of neck at cervical vertebra number 4. You logically see
480.
cervical. Yes. The above injury was antimony nature. Cause of death due to chop wound on back of neck by heavy sharp weapon. Then you logically see the Giridhari where he has struck
one chop wound over
brain of size 2 cm into 1 cm at temporal region loss. One hematoma of size 1 cm into 1 cm, 1 cm present not at temporal region. Naturally cycle consequently hematoma. Paragraph 10. On external examination, I found one chop wound of size 4 cm and 3 cm into 1.5 cm over base of left scapula.
That is scapula.
Yes, bro. 1 cm lateral to midline, one chop wound of size 4 cm and 3 cm and into 1 cm on posterior base of neck. At cervical vertebra at number 6 level. You will see that number 6 level. One chop wound of size 4 cm and 3 cm into 1 cm over left temporal lobe of head 4 cm above left ear. One chop wound size of 5 cm and 4 cm and 2 cm. 5 cm.
All on the
lobe. All this side. Neck and lobe and head. So that shows a premeditation. I will kill him. He has given that blows on that particular vital parts of the body. From that, I humbly pray that this court can infer that the premeditation on the part of the accused to hit in such a way that they will be no more. They have to die because the word used in section 302 so imminently dangerous. That can be qualified here.
And here the case is instantaneous.
Yes.
Intention to death, it can be gathered also apart from other things, the prior conduct, subsequent conduct, the weapon used, the part of the body selected, the force used. These are the things also that also can be taken into account about the intention.
Yes. And I humbly pray your lordship to hold at least that the murder of 3 persons in this way is diabolical, is a dastardly act and revolting nature, grotesque and cruel. With extreme cruelty, the crime has taken place. I like that your lordship should, of course, I humbly pray that in Manoj and others versus state of Madhya Pradesh, there are some guidelines have been prescribed by the Honorable Appellate Court for the trial court at the time of hearing of sentence. In what steps should be taken by the trial court?
235.
Yeah. That has been qualified very clearly.
Manoj.
Yes, Manoj. That is available. ମୁଁ ପଢିଛି ମୁଁ ଖାଲି mark so that your loss can repeat it.
Paragraph
that is plus paragraph 237 to 251.
237. कैसे number
237 to 251.
Manoj case तो?
Manoj case.
Manoj 237 कोटी. Para
237 para 237 to 51. Pre-sentence hearing. Another heading pre-sentence hearing.
এই কেসে কোন দরকার আমার এই কেসে কোন ହେଇଛି
237 says mitigating factor.
এটাও ଟିକେ ବାହାର କଲୁ ଟିକେ ରହ Judgment of sentence part A.
That has been complied with
Just
already.
sentence
that
ର
reason
ଇଏଟା
reports
ଆରମ୍ଭ
were
କେଉଁଠି
closed.
ହେଇଛି ମିଷ୍ଟର ପଟକିଆ ଜଜମେଣ୍ଟ ର ପେଜ
Plus, pardon, plus.
ହଁ ଏଇ ଯୋଉ ଆମର ଇମ୍ପୁନ୍ ଜଜମେଣ୍ଟ ର
Hey,
କୋଉଠୁ ଆରମ୍ଭ ହେଇଛି
It a page 463.
No.
In our trial court.
ହଁ it is hearing on quantum of sentence.
Yes, plus.
ঠিক আছে, now you place this judgment of the Supreme Court, then we'll see.
Yes.
Pre-sentence hearing.
Yes, plus.
हाँ
ऊपर mitigating circumstances गुड़ाक
judgment ହେଲା 7/8/23.
Yes, plus.
अच्छा
Sentence ଟା ହେଲା
9/8/23. Okay.
ଆଜ୍ଞା।
हाँ ପଢ।
Opportunity and obligation to provide, plus in the paragraph 237, just on the previous page, there are mitigating factors have been.
That is the other.
Then 238, this court in Bhajan Singh held that the introduction of pre-sentence hearing to the accused in 1973 through section 235(2) CRPC altered the Jagmohan Singh principle that the court is primarily concerned with the circumstances connected with crime. Therefore, now due consideration has to be given to the circumstances of the criminal. As well, when adjudicating whether the case falls within rarest of rare, and if the option of life imprisonment as an alternative is unquestionably foreclosed. In Bachan Singh, this court categorically stated that the probability that the accused would not commit criminal acts of violence as would constitute a continuing threat to the society is a relevant circumstance that must be given great weight in the determination of sentence. The sentencing hearing contemplated under section 235(2) is not confined merely to oral hearing, but intended to afford a real opportunity to the prosecution as well as the accused to place on record facts and material relating to various factors on the question of sentence, and if interested by either side, to have evidence adduced to show mitigating circumstances to impose a lesser sentence or aggravating grounds to impose death penalty. Plus, in absence of an individual's capacity to effectively bring forth mitigating factors, this court in Bachan Singh placed the burden of eliciting mitigating circumstances on the court, which has to consider them liberally and expansively, whereas the responsibility of providing material to show that the accused is beyond the scope of reform or rehabilitation, thereby unquestionably foreclosing the option of life imprisonment and making it a fit case for imposition of death penalty, is one which falls squarely on the state. This has been iterated and further spelled out by this court in Santosh Bariyar, Rajesh Kumar, Chanulal Verma, and other decisions. In Santosh Bariyar, making observations on nature of information to be collected at the pre-sentencing stage, this court further observed that at this stage, Bachan Singh informs the content of the sentencing hearing. The court must play a proactive role to record all relevant information at this stage. Some of the information relating to the crime can be culled out from the phase prior to sentencing hearing. This information would include aspects relating to nature, motive, and impact of crime, culpability of convict, etc. Quality of evidence adduced is also a relevant factor. For instance, extent of reliance on circumstantial evidence or child witness plays an important role in the sentencing analysis. But what is sorely lacking in most capital sentencing cases is information relating to characteristics and socio-economic background of the offender. This issue was also raised in the 48th report of the Law Commission 242. The state's duty is highlighted in importance even more so in the Indian context, wherein a majority of the accused have a poor or rudimentary level of legal representation. The importance of collecting socio-economic factors in the context of our criminal justice system was critically noted by the 62 second report as follows. Plus, numerous committee reports as well as judgments of the Supreme Court have recognized that the administration of criminal justice in the country is in deep crisis. Lack of resources, outdated models of investigation, overstretched police force, ineffective prosecution, and poor legal aid are some of the problems besetting the system. Death penalty operates within this context and therefore suffers from the same structural and systematic impediments The administration of capital punishment thus remains fallible and vulnerable to misapplication. The vagaries of the system also operate disproportionately against the socially and economically marginalized who may lack the resources to effectively advocate their rights within an adversarial criminal justice system.
So now this is so far
For a
this
moment,
case is
Lordship.
concerned.
For a moment,
235
I would like to draw Lordship's attention. Lordship, I'll read paragraph 242 along with 235. For a moment, Lordship, I'll come to paragraph 235. 235. 262, 260 second report. 230. While the 262nd report recommends the abolition of the death penalty on this ground, in addition to sentencing having become judge-centric or arbitrary, it has not prompted parliamentary intervention. Whether the death penalty deserves to a relook as recommended by Korean Joseph Justice dissenting in Chanulal Verma, in light of 262 Law Commission report evolving jurisprudence, public discourse, and international standards of human rights, is outside the purview of this court's jurisdiction, given the Constitution Bench decision Bachan Singh and a question best left for the legislature to critically consider. In this backdrop, what this court can do is try and bolster the existing sentencing framework.
Yes, yes.
We are not. Yes, that's the reason why I'm lost that 262
so
report
that was lacking in the judgment of the trial court.
Yes.
That 235(2) has not been complied properly, has been taken care of by this court, allowing the condemned convict to put forth his material through affidavit or otherwise. And beyond that also, we have already called for from the jail superintendent. So that part is already met. Probably the principals are looking for that.
Yes, ma'am. And then paragraph. Then 243 loss. However, despite over 4 decades since Bachan Singh, there has been little to no policy-driven death change towards formulating a scheme or system that elaborates how mitigating circumstances are to be collected for the court's consideration. Scarce information about the accused at the time of sentencing severely disadvantages the process of considering mitigating circumstances. It is clarified that mere mention of the circumstances by the counsel serves no purpose. Rather, they must be connected to the possibility of reformation and assist principled judicial reasoning as required under section 230 to 235 2 CRPC. Constrained by this lack of assistance, this court, as mentioned above, in Rajesh Kumar, has even gone so far as to hold that the very fact that the state had not given any evidence to show that the convict was beyond reform and rehabilitation was a mitigating circumstances in itself. The lack of forthcoming information has led to attempts by the courts to look backwards, sometimes many years after the crime has been committed, to evaluate on the one hand circumstances that could not have been paused in time, and on the other those which can be captured but for which there exists no frame of reference from the past for comparison. This inconsistency in some courts calling for reports while others fail to further contributes to our patchwork jurisprudence on capital sentencing and in turn undermines the equality principle and due process protection that Santosh Barrier recognizes as existing in favor of death row convicts. The move to call for a probation officer's report, as done by this court, even in this case, is in fact a desperate attempt by the courts at the appellate stage to obtain information on the accused at present. Good conduct of the accused at the post-conviction stage in prison through a jail report and psychiatric evaluation to evaluate possibility of reform, albeit at the appellate sentence stage, were considered recently in Chanulal Verma as necessary indicators for considering mitigating circumstances. Since the appellant has been in jail, we wanted to know whether there was any attempt on his part for reformation. The superintendent of the jail has given a certificate that his conduct in jail has been good. Thus, there is a clear indication that despite having lost all hope, yet no frustration has set on the appellant. On the contrary, there was a conscious effort on his part to lead a good life for the remaining period. A convict is sent to jail with the hope and expectation that he would make amends and get reformed. that there is such a positive change on a death row convict, in our view, should also weigh with the court while taking a decision as to whether the alternative options is unquestionably foreclosed. As held by the Constitutional Bench in Bachan Singh, it was the duty of the state to provide by evidence that the convict cannot be reformed or rehabilitated. That information not having been furnished by the state at the relevant time, the information now furnished by the state becomes all the more relevant. The standard set by the rarest of rare test in Bachan Singh is a high standard. The conduct of the convict in prison cannot be lost sight of. The fact that the prisoner has displayed good behavior in prison certainly goes on to show that he is not beyond reform. In the matter of probability and possibility of reform of a criminal, we do not find that a proper psychological psychiatric evaluation is done. Without the assistance of such a psychological psychiatric assessment and evaluation, it would not be proper to hold that there is no possibility or probability of reform. The state has to bear in mind this important aspect while proving by evidence that the convict cannot be reformed or rehabilitated. However, this too is too little, too late, and only offers a peek into the circumstances of the accused after conviction. The unfortunate reality is that in the absence of well-documented mitigating circumstances at the trial level, the aggravating circumstances seem far more compelling or overwhelming, rendering the sentencing court prone to imposing the death penalty on the basis of an incomplete and hence incorrect application of Bachan Singh test. The goal of reformation is ideal, and what society must strive towards. There are many references to it peppered in this court's jurisprudence across the decades. But what is lacking is a concrete framework that can be measured and evaluated. Unfortunately, this is mirrored by the failure to implement prison reforms of a meaningful kind, which has left the process of incarceration and prisons in general to be a space of limited potential for systematic reformation. The goal of a reformative punishment requires systems that actively enable reformation and rehabilitation. As a result of nuanced policy making, as a small step to correct these skewed results and facilitate better evaluation of whether there is a possibility for the accused to be reformed beyond vague reference to the conduct, family background, etc. This court deems it necessary to frame practical guidelines for the courts to adopt and implement till the legislature and executive formulate a coherent framework through legislation. These guidelines may also offer guidance or ideas that such a legislative framework should benefit from to systematically collect and evaluate information on mitigating circumstances. Now, here the practical guidelines to collect mitigating circumstances. I'm giving back on the Ramsco.
So finally, we had gone for the sentencing policy, and what has happened finally?
Finally, because they were young, and already I have read because all the three accused persons have told.
See, before in the
No, practical come through. Practical guidelines.
Sentence hearing re defense counsel submission टा देखो मैंने कौन practically किसी ना
plus a guidelines are important. Even if your lordship can frame the guidelines for the trial court.
So now that we have overcome that, the sentencing hearing on sentence as taken by the trial court is not in consonance with the principles
जो
of the
जिनस
guidelines.
गुड़ाक honorable supreme court कहले एई जिनस गुड़ाक मध्य court should consider by calling for the report from the jail superintendent, that probation officer, other things. We have complied with all those requirements.
Unless while sentencing, giving awarding death sentence by the London trial court, the trial court also.
No,
but that is not your case.
Despite
that, the court has come to the death sentence.
Yes.
So the court, rather this court would have taken those aspects that without having this information before the court, how could the court come to this finality?
But my humble here, probably I have not been raised properly. My humble before lordship is that why this honorable court cannot frame a guideline for the London trial courts. Your lordship can come to para 249. So it is clear.
249.
Thus, I was reading 249 as 468 page. Because it is morely a direction to the trial court. To do this, the trial court must elicit information from the accused and the state, both. The state must, for an offence carrying capital punishment at the appropriate stage, produce material which is preferably collected beforehand before the sessions court, disclosing psychiatric and psychological evaluation of the accused. This will help establish proximity in terms of timeline to the accused person's frame of mind or mental illness, if any, at the time of committing the crime, and offer guidance on mitigating factors 1, 5, 6, and 7 spelled out in Bochensin. Even for the other factors of 3 and 4, an onus placed squarely on the state. Conducting this form of psychiatric and psychological evaluations close on the heels of commission of the offense will provide a baseline. This is important. Will provide a baseline for the appellate courts to use for comparison. That is, to evaluate the progress of the accused towards reformation achieved during the incarceration period, pre-conviction stage and post-conviction stage, so that appellate court can assess it. So it is plus a guidelines for the trial court.
For all.
Yeah.
For all in a way.
For all. But,
even for the appellate court.
But yes, plus.
So there is a departure on the part of the trial court with regard to these principles enunciated by the. Anyway, this has been taken care of by the appellate.
Yes.
This judgment was pronounced on
20th May 2022.
By that time, all these judgments were in force. It a typical judgment.
It 23 was that?
It 23. The 45 रे pronunciation. Then came the judgment rendered by the bench of 3 judges, authored by Honorable Dr. Justice Dhananjay Y. Chandrachud.
Yes.
Yes.
Where this question of calling for the report.
Yes.
तो मनोज के ଆଉ କିଛି ପ୍ରେସ୍ କରିବାର ନାହିଁ
ଏଇ ଗୋଟେ ସେଟା ରିଭ୍ୟୁ ପିଟିସନ ଯୋଉଟା ଥିଲା ଜଷ୍ଟିସ ଚନ୍ଦ୍ରଚୂଡଙ୍କର
ହଁ ସେଇଟା ଦିଅ ଆମେ ବୋଧେ
already we have cited it.
We have cited in that
in our order.
Yes. Order. There plus your hospitality paragraph because there he was 23 years old. The accused was 23 years old. That is one of the ground whereby the death penalty has been reduced to life imprisonment. And there one child was killed because there they were 3 sisters and one brother, only one child. And there in the court, the lady was crying because she had lost her only male child, and that is the ground why ultimately death sentence has been imposed and ultimately upheld by the High Court and also by the Honorable Apex Court. Then plus in a review petition, it has been taken into consideration regarding his reformative aspect and his young age, and then plus that has been commuted to a life sentence of I think 25 years. That you'll also get page paragraph 88, 89. There are several judgments also has been referred. The paragraph 86, as per the written submission of the petitioner, he was aged about 24 years old when the judgment of the trial court was rendered on 30th July 2010. He has been in prison since 2009, 13 years. He had no prior antecedents, and the jail authorities have stated that he has not been involved in any other case. 13 वर्ष पर रिपोर्ट मगाई କରିଛନ୍ତି good conduct. That is the reason why the Honorable Apex Court. नहीं सॉरी ना अपन बारंबार सबला करछन
कौन है जी
Learned friend.
You proceed. We are not disturbing you.
He has not brought his spec, and my line friend stated at the very threshold. He has not brought his spec, and at the threshold he told, "I look by your spec."
Full opportunity is to be provided to both of you, and we are giving.
Because I am addressing as a public prosecutor.
We are giving you full opportunity, and we have also said that we are giving to the openly said that whatever materials you also want to place, that Nabin we said that whatever you want, even if you want to say something, you can say. There is no.
It all includes even my submissions also.
No, I get. But don't put his spec because he will also look in a different.
That ମୁଁ ସେଟା ଇଂଲିଶ କରୁ କରୁ ଏ ଟ୍ରାନ୍ସଲେସନ ହଉନି ଓଡ଼ିଆଟା ମୁଣ୍ଡକୁ ଯାଉଛି ଇଂଲିଶଟା ବାହାରୁଛି ମୁଁ କହିଲି ତମ ଆଖିରେ ଦେଖିଦେବି ସ୍ପେକ୍ସ ନବା କଥା କହିନି।
Yes,
And there in the I forgot, I'm sorry, Milas. In that Manoj and others case, your lordship also may kindly peruse paragraph 228 to 233. I'm sorry, Milas. That is no judge-centric approach should not be given. But in that case,
No, you have read 235.
223.
You read 235.
228 to 235. 8 plus. Then is covered. Then I will go for the alternative argument clause. Suppose there is no death sentence. Well, next two judgments was
in some judgments it is said he should not be released unless he undergoes this that type of judgment you want.
No, because here suppose your lordship is not going.
It is stated that he should not remainder of life,
non-repetitive sentence of
then
35 years.
30 years he should not be this provision should not, it cannot be resorted to 433 years.
Yes, that is Swami Radhanand starts plus our High Court judgments are also there. Your lordship has delivered recently judgment, and but I want to add something more. That is because 3 persons have been killed, so far as Navin is concerned, and so far as the other accused is concerned, he is involved. Taking the aid of section 34, is involved.
He is the life imprisonment.
Life. There must whether 1 life imprisonment should be given or 3 life imprisonment should be given. The law laid down by the Honorable Appellate Court is because 3 persons have been killed. There are 3 crimes. So for 3 crimes,
who against whom you are arguing?
Navin. Now suppose your lordship is not passing an order of conviction, so awarding death sentence. The alternative argument is that 3 life sentences should be imposed, which will run concurrently, as has been held by the Honorable Appellate Court in a constitution bench judgment. The judgment I have given was.
No, is it when the state is also not challenging anything, can that be done?
Is it not an enhancement of?
No, not enhancement. If concurrent going of life imprisonment, if a lordship is passing not, and your lordship passing an honorable sentence of 35 or suppose.
We can say that there is already a notice is there. We can take it that way. But then
because one sentence has been passed.
No, what is the mandate of this?
Mandate velocity is like
not an enhancement.
No, not enhancement. Not enhancement. It is challenged because in one judgment, because that was a, the Honorable High Court has passed that it will run consecutively. 2 life imprisonments, it will run consecutively.
Yes, that is the way, but other offences are there.
No, plus there is why it has been referred to the larger bench. And the other 2 judgments, they were saying it will run concurrently.
Right.
So whether it will run concurrently or consecutively, for that reason it was referred to the larger bench.
Right.
So constitutional bench comprising 5 judges, they have decided, no, it will run concurrently. Even if 3 life imprisonments are being passed, it will run concurrently. Suppose, looking at the gravity of the cases, your lordship suppose will be pleased to pass a 35-year non-repetitive sentence so far as Giridhar is concerned or Piruvadi is concerned, some or other. Why 3 sentences are required? Because at the time of consideration remission by the board, sentence review board, then in one case he may be remitted, and the other case he may not be remitted. His case cannot be considered. But if 1 life sentence is being passed, then his case can be considered for remission.
That analogy, that when a sentence under 302 is passed, there is also a provision for sentence of fine.
Yes.
Otherwise, after 302, if the person is for the remainder of life, where is the question of fine?
Yes.
It is for this reason that in case of a commutation, the fine remains as it is. Sentence has to be. So the analogy is this: in case of a conviction with regard to one offense of the murder, there could be 2 also. So remission, if could be for one, seeing the gravity in other 2 cases may not.
That is the analysis given by the Honorable Appellate Court. That my compilation at page 173. I have given the 2 judgments whereby it has been referred. That starts at page 169. Muthuram Lingam and others versus state.
Oh, that is regarding that.
Yes, Master.
Page
169 plus.
Para 7.
Para 7. ତା ଉପରୁ ଟିକେ ପାରା 6 ର ଲାଷ୍ଟ 4 ଲାଇନ୍ସ ଜଷ୍ଟ ପାରା 172 ରୁ ଟିକେ ପଢି ଦଉଛି
31.
172 para 6 ର last portion. We are of the opinion that the appellant is liable under section 302 IPC for imprisonment for life for each of the 3 offences of murder under section 300 IPC, and the imprisonment of life should not run concurrently but consecutively, and such punishment of consecutive sentences of imprisonment for the triple murder committed by the appellant will serve the interest of justice. Then, it is evident from the passage extracted above that there is an apparent conflict in the views taken by the different benches of this court on the question whether consecutive life sentences are legally permissible. While in O.M. Cherian case, this court has held that such consecutive life sentences are not permissible, the view taken in Kamalnath and Sahanullah case appears no strike a discord note. So also the decision in Duryodhan Raut case holds that consecutive life sentences are not permissible in terms of section 31 on account of the proviso to subsection 2 of section 31 not permitting any such consecutive life sentences, for the cumulative effect of such sentence shall inevitably take the total period of imprisonment for more than 14 years. Suffice it to say that the question that falls for a determination is not free from difficulty, and the cleavage in judicial opinion as to the true and correct legal position needs to be authoritatively resolved. It is interesting to note that the appellants have been sentenced to undergo several consecutive life sentences ranging between 2 to 8 such sentences. In the circumstances, therefore, we are inclined to refer to the constitutional bench the following question, which is the only question raised in these appeals for an authoritative pronouncement: whether it is legally permissible for a court to award consecutive life sentences to a convict based on a series of murders for which the convict was tried in a single trial. Then the answer is on the next page, 173. In the Placido Melos C.
Yes. Multiple sentences.
Whether they are to run sentences that may be awarded, whether they are to run consecutively or concurrently when multiple sentences awarded, none of them being life imprisonment. Multiple sentences awarded, some being term sentences and one sentence of life imprisonment. Multiple sentences of life imprisonment only, and multiple sentences awarded, some being term sentences and multiple sentences of life imprisonment. Effect of remission, commutation of one sentence of life imprisonment when multiple sentences of life imprisonment are imposed. Firstly held, multiple term sentences and or multiple sentences of life imprisonment may be imposed when a person is convicted of several offences at one trial.
Here there is no multiple sentence has been imposed.
Term sentence has not been imposed. Yes, not imposed.
Imposed.
Not imposed. One life imprisonment has been imposed in a regular way.
So the question that crops up for consideration, when multiple sentences have been imposed, so whether it is to be concurrently done or consecutively done. When multiple sentences has not been imposed, why should we look into this?
I humbly pray that multiple sentences should be imposed. That is my humble prayer.
Then again the question that arises that whether it would that amount not enhancement of the sentence.
Absolutely not. Because suppose even if your lordship is passing an order of 35 years non-renewable or for the remainder part of the life, even in all the three, he is no way affected. The accused not being prejudiced.
He is prejudiced. Reason being, in case of a commutation, suppose, in case of a commutation as you submitted, in one case, the other case are not going to be committed.
But the charge has been framed. The charge in framed, yes.
Charge has been framed. No doubt. So that is how I am saying it is enhancement of punishment, not charge. He has defended himself.
Yes.
But only in respect to the impression that he is going to be facing a trial for one murder, taking into the three offences under one transaction.
Plus, had it been life imprisonment, if I am praying that for a death sentence, that is enhancement. But when already death sentence has been passed, and suppose it is being commuted by your lordship to the life imprisonment.
Oh, you are saying that the extreme has been
passed.
Punishment
has been passed.
Now
if it is being commuted, so why not 3 life imprisonments?
Right.
Why 1?
Right.
Because that will sound good to the society. That is, this person has committed 3 murders.
No, that is not enhancement according to you.
Yes.
Because we are
minus. And that can be done in view of the judgment passed by the Honorable Apex Court.
Which
Because now it
paragraph?
is this court to impose.
Yes,
Which paragraph?
Madam Laws, 173.
Hmm. No, 173. This is a placetam.
No, I am taking the paragraph, exact paragraphs.
We'll take up after lunch. We'll
Yes,
continue.
smiles.
After lunch, I have a problem. Part-time matter is fixed.
No, it's all right. We'll hear him continue.
I will
Because
come back and
tomorrow there may be a single bench.
No, Aji sir, no,
As it appears in Friday.
I may be excused for 15-20 minutes.
Item number 3.
My pleasure, Lordship. The last judgment I was citing. That I have written the paragraph in the top. Like the other ones, paragraph 8, 10, 18, 31, 34. 173. Page 173. 173, drawing page. Of the compilation.
So you started for a
No, no, I am starting with para 4, 5. I am adding just 4 and 5.
Just please place the few 1, 2, 3 paragraph. Then you. Yes. That's good. That is at page 178.
Yes, ma'am. A bench comprising 3 judges of this court has a report towards the following short but interesting question: whether consecutive life sentences can be awarded to a convict on being found guilty of a series of murders for which he has been tried in a single trial. The question arises in the following circumstances. The appellants were tried for several offences, including an offence punishable under Section 302 of the Indian Penal Code, 1864 short IPC, for several murders allegedly committed by them in a single incident. They were found guilty and sentenced to suffer varying sentences, including a sentence of imprisonment for life for each one of the murders committed by them. What is important is that the sentence of imprisonment for life for each one of the murders was directed to run consecutively. The result was that the appellants were to undergo consecutive life sentences ranging between 2 to 8 such sentences, depending upon the number of murders committed by them. Criminal appeals preferred against the conviction and the award of consecutive life sentences having failed, the appellants have filed the present appeals to assail the judgment and orders passed by the courts below. I am reading paragraph 4. When the appeals came up for hearing before a 3-judge bench of this court, the learned counsel for the appellant appears to have confined his challenge to the validity of the direction issued by the trial court and affirmed by the High Court that the sentences of imprisonment for life awarded to each one of the appellants for several murders allegedly committed by them would run consecutively and not concurrently. It was argued that in terms of Section 31 of the Criminal Procedure Code 1973 for short CRPC, the sentence of the life imprisonment awarded to the appellants for different murders alleged to have been committed by them could run concurrently and not consecutively as ordered by the trial court and the High Court. Reliance in support of that submission was placed upon a decision of a 3-judge bench of this court in Om Cherian versus State of Kerala and a 3-judge bench decision of this court in Duryodhan Raut versus State of Odisha. Of course, I could have provided the judgment, I have not provided because it will be bulky. That is the reason why I have not.
Yeah.
5. On behalf of the respondent state of Tamil Nadu, Reliance appears to have been placed upon 2 other decisions of this court in Kamalnatha versus State of Tamil Nadu and Sanaullah Khan versus State of Bihar to argue that it was legally permissible to award more than one life sentence to a convict for different murders committed by him, with the direction that the sentences so awarded shall not run consecutively. The bench, hearing the appeal, noticing a conflict in the views taken by this court on the question whether consecutive life sentences were legally permissible, directed the matter to be placed before a larger bench comprising 5 judges to resolve the conflict by an authoritative pronouncement. That is precisely how these appeals have been placed before us for an authoritative pronouncement.
Yes.
Philosophical
Paragraph 8. Now you can hear. You want to place?
Paragraph 8 plus. Next page plus.
Yes.
180. Interpreting section 31(1), a 3-judge bench of this court in O.M. Cherian case declared that if 2 life sentences are imposed on a convict, the court must necessarily direct those sentences to run concurrently. The court said, section 31(1) CRPC enjoins a further direction by the court to specify the order in which one particular sentence shall commence after the expiration of the other. Difficulties arise when the courts impose sentence of life imprisonment for life and also sentences of imprisonment for fixed term. In such cases, if the court doesn't direct that the sentence shall run concurrently, then the sentences will run consecutively by operation of section 31(1) CRPC. There is no question of the convict first undergoing the sentence of imprisonment for life and thereafter undergoing the rest of the sentences of imprisonment for fixed term, and any such direction would be unworkable. Since sentence of imprisonment for life means jail till the end of life, till the end of normal life of the convict, the sentence of imprisonment of fixed term has to necessarily run concurrently with life imprisonment. In such case, it will be in order if the session judges exercise their discretion in issuing direction for concurrent running of sentences. Likewise, if 2 life sentences are imposed on the convict, necessarily the court has to direct those sentences to run concurrently. To the same effect is the decision of a 2-judge bench of this court in a Duryodhan Raut case, in which this court took the view that since life imprisonment means imprisonment of full span of life, there was no question of awarding consecutive sentences in case of conviction for several offences at one trial. Relying upon the proviso to subsection 2 of section 31, this court held that where a person is convicted for several offences, including one for which life sentences can be awarded, the proviso to section 31(2) shall forbid running of such sentences consecutively. It would appear from the above 2 pronouncements that the logic behind life sentence not running consecutively lies in the fact that imprisonment for life implies imprisonment till the end of the normal life of the convict. If that proposition is sound, the logic underlying the ratio of the decisions of the court in O.M. Cherian and Duryodhan Raut cases should also be equally sound. What they need to examine is whether imprisonment for life does indeed imply imprisonment till the end of the normal life of the convict as observed in O.M. Cherian and Duryodhan Raut. That question in our considered opinion is no longer res integra, the same having been examined and answered in the affirmative by a long line of decisions handed down by this court. We may again pull you, then Gopal Binayakas and every judgments have been passed. I will come to paragraph 18. The legal position is thus fairly well settled that imprisonment for life is a sentence for the remainder of the life of the offender, unless of course the remaining sentence is commuted or remitted by the competent authority. That being so, the provisions of section 31 under CRPC must be so interpreted as to be consistent with the basic tenet that a life sentence requires the prisoner to spend the rest of his life in prison. Any direction that requires the offender to undergo imprisonment for life twice over would be anomalous and irrational, for it will disregard the fact that humans, like all other living beings, have but one life to live. So understood, section 31(1) would permit consecutive running of sentences only if such sentences do not happen to be life sentences. That is, in our opinion, the only way one can avoid an obvious impossibility of a prisoner serving 2 consecutive life sentences. Verse 30. paragraph 31 at page 189. The above view runs contrary to the ratio of this court's decision in Cherian's case and Duryodhan Rao's case. That apart, the view taken in Kamalnath's case has not noticed the basic premises that a life sentence once awarded would imply that a prisoner shall spend the remainder of his life in prison. Once that happens, there is no question of his undergoing another life sentence. Plus, this is important. Next slide. To this extent, the decision in Kamalnath's case takes the view that the court can, for each offense, award suitable punishment which may include multiple sentences of imprisonment for life for multiple offenses punishable with death. There is and can be no quarrel with the stated proposition. I mean to say multiple sentences can be passed. Life sentences can be passed. Yes. The court can indeed ought to exercise its powers of awarding the sentence sanctioned by law, which may include a life sentence. But if the decision in Kamalnath's case purports to hold that sentence of imprisonment for life can also be directed to run conjugal, the same doesn't appear to be sound for the reasons we have already indicated earlier. I humbly pray your lordship to come to paragraph 34.
This does not appear to be sound for the reason.
Yes, for the reasons we have already indicated earlier.
That cannot.
I like to gote sarla pore na gote asibo tame gote consecutive dele kemti hobo. Yes. Yes.
Then we need to remember that award of multiple sentences of life, so that such sentences are superimposed over one another is entirely different from directing such sentence to run consecutively. Paragraph 34 and 33 last line was I'm reading. To the extent these decisions may be understood to hold that life sentence can also run consecutively, do not lay down the correct law and shall stand overruled. 34. In conclusion, our answer to the question is in the negative. We hold that while multiple sentences for imprisonment for life can be awarded for multiple murders or other offences punishable with imprisonment for life, the life sentences so awarded cannot be directed to run consecutively. Such sentences would, however, be superimposed over each other so that any remission or commutation granted by the competent authority in one doesn't ipso facto result in remission of the sentence awarded to the prisoner for the other. So this is the purpose why 3 life sentences can be awarded. Plus, coming to our case now.
So that means even if what you are advancing the argument, suppose for 3 murders,
Yes.
3 imprisonment for life is awarded,
Yes.
then it can be said that all the life imprisonment sentences are to run concurrently.
That is the sound proposition of law.
But not, you cannot say it to run consecutively. But the human being is one life, so that is what they have stated. Yes.
So concurrent
and suppose in one out of the 3 murders, in one murder, suppose the appropriate government, if we do not fix any rider, like 20 years, 30 years, or the remainder of life, then even if the state wants to, appropriate government wants to remit the sentence, commute the sentence, then they are to either do it in all the 3 cases so that it can come out early, or even if they do it on one case, he cannot come out in the others. That's what you want.
That is the purpose. That is the purpose. As because the death sentence has been imposed, so there is no, there need not be any quarrel on the point that it is being scaled.
Direction affirmed by the High Court is that the said term sentences shall run consecutively.
It was contended on behalf of that even that part of the sentence is not legally sound. For one person is sentenced to imprisonment for life, the term sentence ordered to must run concurrently. We don't have a thing, so the power of the court to direct
the order in which sentences will run in unquestionable in view of the language employed in 31
court can however legitimately direct the prisoners on first come to go term imprisonment before the तामाने सेटा कहउछन ए सेंस रे जदि कोनोसी सेंटेंस रे 5 वर्ष हेतिबो ताहले तापरे आ गोटे सेंटेंस पय लाइफ
आगो 5 वर्ष देन लाइफ concurrent running रे सेटा
prisoners shall first undergo the term sentence
yes
before the commencement of the life sentence.
yes
Such a direction shall be perfectly legitimate and in tune with section 31 of CRPC. The converse, however, may not be true, for if the court directs the life sentence to start first,
yes
it would necessarily imply the term sentence would run concurrently. That is because once the prisoner spends the life in jail, there is no question of his undergoing any further sentence. Whether or not the direction of the court below calls for modification or alteration is a matter with which we are not concerned. The regular bench hearing the appeals is free to deal with that aspect once. Yes.
This is for the purpose of deciding that question, which is to be answered by the constitutional bench, and that has been answered. So, the view taken in OM Cherian versus State of Kerala is 2015 to SCC 501 and Duryodhan Raut versus State of Odisha 2015 volume 2 SCC 783 that holds good.
Yes.
Then my next argument is that is regarding non-immutable sentence. As has been first initiated by, in the case of Swami Sradanand versus alias Murli Manor Mishra versus State of Karnataka, reported in 2008, volume 13, SCC 767, and reported in many judgments of our Honorable High Court, including a judgment passed by Lordship in Muhammad Mustaq, State versus Muhammad Mustaq. So I am giving those numbers, death reference numbers. That is looking at the gravity of the offense, and as with two ladies and one person has been killed. I humbly pray the if it is not being a death sentence, my alternate prayer is that at least they should be punished and he should spend all his remaining part of the life behind the bar. And so far the lady Pirovati is concerned, and she is quite different from the other Savitri and Giridhari, because Savitri being the daughter and Giridhari being the son-in-law, Iladam son-in-law. Because there is no animosity, because Pirovati was fighting the litigation. So if at all he has got any grievance, that grievance is against Pirovati. Because Savitri is her successor, and I mean the other accused being his husband, there should not, for that reason, he should not extinguish them entirely from this mortal world. And for that reason, non-immutable sentence should be awarded. So I leave it to your lordship's appreciation.
No, the other that in PW1 who saw the occurrence, he is the sister of that Savitri, na?
Yes, is his
She is
sister.
she is also the successor. Why you say that only Savitri is the successor?
Yes, your lordship is correct. PW1 is also the successor. And Savitri and PW1.
Right. Even if after the elimination of Savitri and this that man, even their two children also comes into picture.
Yes.
It cannot be said that only that.
So the entire I leave it to lordship's judicial discussion regarding imposition of non-immutable sentence. And to that extent, if your lordship will permit me, then I can provide the judgments. Swami Sradanand and the judgment passed by the Supreme Court in death reference number 2/2010.
That is there we have
Yes.
taken into account so many decisions from this.
And the act committed by the accused is brutal, grotesque, diabolic, dastard, and revolt. Because my lord was asking regarding what is grotesque. Of course, I went to the dictionary what the meaning of grotesque and what is the meaning of brutal. To know all these things, was I have worked little more. And brutal, that means as per the dictionary meaning, that is inhuman, cruel, like a brute, belonging to the animal, lower animal. And grotesque as it means extravagantly formed, excessive, unrestrained, irregular, wandering beyond sounds, fantastic, ludicrous, and absurd. This is plus the
That
and
means if one injury
yes,
could have been enough to take the
yes, boss.
result there,
Yes, boss.
but several
Yes,
injury.
giving again and again blows and Chambers dictionary plus all the meanings I have got.
Yesterday we are mentioning about this Hindu Succession Act 1956, this section 25, murderer disqualified. That was
It may be that at some point a murderer feels that once I finish the other side, I'll be stepping into the shoe of that. But
This is not
person with life imprisonment is not that way.
not possible.
a person who commits murder or abates the commission of murder shall be disqualified from inheriting the property of the person murdered or any other property in furtherance of the succession to which he or she committed or abated the commission of the murder. That is in the Succession Act, section 25.
Section 25 plus.
Yes.
And it is diabolic. That means extremely unpleasant, very bad, devilish. And of course, this case killing in a row three persons, it is devilish. So it is also diabolic. And it is a dastardly act. Dastardly means a cowardly fellow, loosely, one who does a brutal act without giving his victim a chance. That is the reason why this the act of the accused is also dastardly, because he has not given a chance to any of the victims to raise any protest from their side, and it is revolting because of the civil dispute. That means to renounce allegiance, to rise in opposition. To rise in opposition, opposition means because of the civil dispute, he has done all these things. So the act committed by the accused is not only brutal, it is grotesque, dastard, and revolt. I humbly pray for Lordship that may be held. This court may kindly held that yes, the act of the accused is brutal, grotesque, diabolic, dastardly, and revolting. And for the entire argument advanced before Lordship, the award, the death sentence should be answered in affirmative, and the appeal filed by accused Navin and so also should be rejected. May kindly be rejected. I'm sorry. And same analogy also be applied with the aid of section 34 so far as the other co-accused is concerned, because two life sentences should be passed so far that person is concerned, because he has aided the killing of Viruvati and also Savitri. That is my humble subject apology.
Okay. So, Muharri, Mr. Sarangi, would want to then close this If anything you want to file, you can file by way of written note of argument. By Monday you can file, there is no problem. You know, the on
He's arguing a matter before another bench will also I will inform.
no, it's all right. I'm खाली କହିଦେବେ ଏଇ ବିଷୟରେ ଯଦି କିଛି if he wants to, because in the order sheet we will write that.
Yes.
If any.
No, he has told me to he will come after finishing that case.
Achha.
I'll convey.
Okay.
ନବୀନ ଦେହୁରୀ ସମସ୍ତ ଯାହା ଆର୍ଗୁମେଣ୍ଟ ହଉଥିଲା ସରକାରୀ ପକ୍ଷ ସବୁ ଦାଖଲ କରୁଥିଲେ ଏସବୁ ତମେ ଶୁଣି ଆସିଲଣି ତମ ତରଫରୁ ଆଡଭୋକେଟ ଷଡଙ୍ଗୀ ମଧ୍ୟ ଯାହା ସବୁ ତଥ୍ୟ ଦାଖଲ କରୁଥିଲେ ତାହା ମଧ୍ୟ ତମେ ଶୁଣିଛ ବର୍ତ୍ତମାନ ଏହା ଉପରେ ଯଦି ଆଉ କିଛି ତମର କହିବାର ଥାଏ ତାହେଲେ ତମେ ତମର ଓକିଲ ବାବୁ ଯୋଉ ରାହୁଲ ଅଛନ୍ତି ଗର୍ଡିଆ ତାଙ୍କୁ ଖବର ଦେଇକି ଷଡଙ୍ଗୀ ବାବୁ ଯିଏ ଅଛନ୍ତି ଏଇଠି ଓକିଲ ବାବୁ ତାଙ୍କୁ ଖବର ଦେବେ ଯଦି କିଛି କହିବାର ଥାଏ ଠିକ ଅଛି ଆମେ ଏଟା ସୋମବାରକୁ ରଖୁଛୁ ଓକିଲ ବାବୁ କୁଆଡେ ଗଲେ ରାହୁଲ ତାଙ୍କୁ ଡକେଇବେ ହେଲା ଯଦି କିଛି କହିବାର ଥିବ ତାଙ୍କୁ ଯୋଗାଯୋଗ କରି ଷଡଙ୍ଗୀ ବାବୁଙ୍କ ସହିତ ଯୋଗାଯୋଗ କରିକି କହିବେ ଏଇଟା ଆମେ ସୋମବାରକୁ ରଖୁଛୁ ସେଦିନ ଆମେ କ୍ଲୋଜ କରିବୁ ଠିକ ଅଛି
Yes, I'm filing and one aspect I bring to Lordship kind notice. Once your Lordship has said that yes, juniors should be groomed. Junior counsel should be groomed. Of course, I don't know whether I have groomed or not. Ms. Gayatri Patramalas has helped a lot in this case and worked hard, and also Mrs. Susmarani Sahu. I humbly promise their names.
No, okay, just give it.
ଆମେ ଏଟା ସୋମବାରକୁ ରଖୁଛୁ
देखिए एटा से जो स्लिपटा दिला आज किसी साइटेशन से रिप्लेस कर चेंज ना नहीं चेक कर से जो बॉन्ड्सटा देखलो और आज किसी सील फिल ना तो आर फर्दर आर्गुमेंट फ्रॉम अच्छा किसी ऑर्डर तो लिखा हूं नथला ना माने आगु भी सब दिन लिखा कल लेकिन हार्ड मिस्टर देवाशीष सरंगी so also for learning amicus curie. So also Mr. Janmay Katkia, learned traditional government advocate, being assisted by Thankford MC Deaton. The land council for both the parties submit that the matter may be taken up on 22nd July 2024 to file the written note of submission. If any, place this matter on 22nd July 2020. The heading रहिबो बुझिलो लिस्ट जदी करिवो तो करिवो फाइलिंग ऑफ रिटन नोट ऑफ आर्गुमेंट एंड करिवो पूरा पेज ब्रैकेट
Last 2 days hearing on sentence. What is that?
it will cover part 230.
So that's all. Thank you very much, Mr. Katkia, for your efforts and have done a good job. That is the thing which the court expects from a counsel, and we are really happy for that. And any other matter is ready, Mr. Any jail criminal appeal, anything?
48
Is the counsel present?
Malad one, may I pardon?
କାଲି କହିଥିଲେ ଆସିବ ବୋଲି
କାଲି କହିଥିଲେ ଯେ
May I pardon?
Sorry, you really should have.
Yes, yes.
Mr.
Malad. Due to rain, I am held up here. Malad, I am just reaching one item. Malad, remember that regarding the one hand cut and the one amputation of one hand, Malad. That was pending just only because of that some decisions my lord wanted, and that was only pending. That is only for judgment, my lord.
So where is the counsel?
He is there, my lord. Also, he was also waiting till Ellen. So that matter can be.
No, you just remind us because tomorrow there may be a single bench. So we take up that matter after this written note of argument is filed or whatever maybe, and these orders or admissions are taken up. We can take up that matter. So जो हाथ तो कटा ये था तो हाफ excessive bleeding ही की death हला. After 2 days now. Okay. So that matter can be taken up. ऐसे पाठ आठ देखी जो. कितना नंबर item?
सेटा my lord
64. ऐसे मन पकी दो तो. Further argument तो लिखा ही. Item 64. So then ask Mr. Bhuiya to remain present on that day.
Bhuiya is there, my lord. Barsa very good help agency.
That's all right. We will take up that after this fresh admissions and orders are over. We will take up that matter first because it's really a part-hard matter, of course. Okay. Thank you.
In the light of paragraph 20. Paragraph 20 of 1995 8 OCR 435. That Devendra Pradhan. That allows me kind of errors.
What is it?
95. 453. Page
450.
Devendra Pradhan or Rao?
No, I lost my understanding.
Devendra Pradhan.
Yes.
Para
20, that's deputy in a more finer way. That is in the lighter way notice.
Oh, okay.
No.
No, that's a live streaming of for the